Jurisdictional.
Jurisdiction is not jurisdiction.
Jurisdiction.
There is no jurisdiction. Jurisdiction, right?
Jurisdiction.
The jurisdiction. Define jurisdiction.
Jurisdiction.
Jurisdiction
is a type of jurisdiction. Jurisdiction. The word jurisdiction.
Jurisdiction. Do you want to set the stage for sort of what this discussion is going to be, or do you want me to?
Yeah. No, happy to do it. I think the question is whether or not the Supreme Court ruled that Boseberg lacked jurisdiction in this case involving the Alien Enemies Act that occurred, originated in the District of Columbia, went up to the DC Circuit Court of Appeals, and then to the Supreme Court. And so I guess the question is a pretty narrow one, which is whether or not the Supreme Court, that is, ruled that Boseberg had jurisdiction or not.
Right.
And I think that he did.
Okay. And I'm going to say that they ruled that he didn't. Just the reason that we are having this discussion is we had a Spaces. It was sort of impromptu. It started off talking about something else and went into the weeds, talking about issues like if we were going to have a debate, which was tangentially scheduled with modern day debates. It's another conversation. But
we often do this.
But nonetheless, I had made the point that I thought it was clear that Boseberg didn't have jurisdiction. You said, no. He did have subject matter jurisdiction, and then said he had jurisdiction in general. So you will be arguing, your position isn't going to be, well, he didn't have jurisdiction, but he did have subject matter jurisdiction. You're not going to argue that.
The position is he had jurisdiction, and that the dismissal, what the Supreme Court ruled had nothing to do with his subject matter jurisdiction. Oh, sorry, that it with his jurisdiction, and that a dismissal about venue, and these are all ways of saying the same thing, kind of, that a dismissal based on venue is not a dismissal based on jurisdiction.
Okay. All right. So we could start anywhere you want. I think it would be worthwhile to start with a definition of what jurisdiction is, but it's up to you.
I would rather go through my argument, but the argument will entail looking at the definition of jurisdiction. I've laid that out in a series of tweets, and I think the argument is logically valid. And if the premises are true, the conclusion is true. And if the conclusion is true, it's clear that the dismissal, even at accepting that it was a venue-based dismissal, that it was not jurisdictional and it's not based on jurisdiction. And so I've laid out an argument. You can take an agnostic position. You can take whatever position you want, but I think that's a good way to proceed, because I think if my argument holds true, I win the debate.
Okay,
I think it's a valid argument. So it's just a question. Yeah.
So we could start with, you can give your argument and I can give my argument, and then I have premise and conclusion as well, and then we'll start with yours, and then we can move on to mine. So you go ahead and give your premises and conclusion, and then I'll give mine. How's that sound?
Sure. No problem. If the habeas territorial jurisdictional rule is a venue rule, then it is not a jurisdictional rule. That's H implies not J. The second premise is the habeas territorial jurisdiction rule is a venue rule. That's H. Therefore, conclusion. The habeas territorial jurisdiction rule is not a jurisdictional rule. So if it's the case that that's the argument. If you grant that argument, I win, because at most the Supreme Court issued that that the habeas territorial jurisdictional rule made it so that the case couldn't be brought under Boseberg, and it being not a jurisdictional rule, it's not a dismissal based on jurisdiction. So that's the argument. I
have two arguments, and I think that they work concurrently with each other. But if somehow it was argued that they don't, I think if I win either of these, I win the debate. The first is premise one. Jurisdiction is the court's power to decide a case or issue a decree. Premise two, the Supreme Court ruled Boseberg did not have the power to decide this case or issue a decree. Therefore, conclusion, the Supreme Court ruled that Boseberg did not have jurisdiction. The second argument I have is premise one, for core habeas petitions, jurisdiction lies in only one district, the District of Confinement. Premise two is the Supreme Court ruled the remedy for the plaintiffs would only be through habeas petitions. Premise three is Boseberg's jurisdiction is not the area of confinement. Therefore, the conclusion, the Supreme Court ruled Boseberg does not have jurisdiction. Fair enough. We can start with yours if you want.
Sure.
I would think that
yeah,
even if you would win your conclusion, I think both of mine would supersede them, and that if you win yours and I win mine, it would still be a ruling of not jurisdiction.
So if my argument follows, if it's true that it was not based on jurisdiction, I see a contradiction. How can it be how can my argument follow where it's not a ruling based on jurisdiction, it's not dismissed for jurisdiction, and your argument also be true that it is? That seems like logically impossible.
It wouldn't be, because it depends on how we would define the term jurisdiction, right? And so therefore, I think that your argument could hypothetically be true, talking about specific types of jurisdiction, but not jurisdiction in general. And so therefore, if it's true that, and that's why I wanted to start with the definition, I think you'll concede the definition, because I had a definition that was very similar to yours. I saw your Black's Law Dictionary definition. That's basically premise one. In my first argument, that's premise one. I don't think you'll dispute that. Premise two is the Supreme Court ruled that Boseberg did not have the power to decide this case or issue a decree. If I win that the Supreme Court said that, and you agree with premise one, that's it. The Supreme Court's ruled that he doesn't have jurisdiction.
Yeah, but they can't both be true. Listen, let's
go through yours first. That's fine.
Yeah. Okay. Awesome. So the first question I'll ask is: you've seen the argument. Do you grant the argument?
No, I don't.
Okay.
And I've reasoned. So the first, you want to do sort of a quid pro quo with questions? Is that fair?
Yeah, sure. You can ask me questions and stuff.
Okay. Can you define jurisdiction?
Sure. So jurisdiction as used in my argument is a court's power to decide a case or issue a decree.
And where is that
by
definition?
Black's Law definition.
That's Black's Law.
That's from Black's Law definition. Alternative one is this is from the Supreme Court. The jurisdiction of the federal courts, their power to adjudicate. So power to adjudicate.
Okay. Why should we prefer
definition?
Why should we prefer Black's Law?
That's
I'm not being
argument.
contentious here. I'm just arguing as a layman. But why do you? Is this just a place that's authoritative, and so therefore that's why we should prefer this definition, or is it just you think this summed up in a way that what you believe jurisdiction is? Or is it both?
That's not the argument. The argument isn't. It doesn't rely on whether or not you should prefer a definition or not. So that's not part of the argument. Is whether we should prefer, one definition over another.
Well, if I present a different definition, like I'm asking why this one definition you gave, do you think is good?
But that's not the argument. So the argument, you can either disagree with one of the premises, or you can, that's semantic. If you want to, we can go into like what terminology should mean. But the argument isn't about which definition is preferable.
Okay, fine. Then just real quick for the layman, since you are an attorney and I'm not, a couple of the terms within those two definitions. The second definition you gave is from the Supreme Court.
Yep. So
what's the term adjudicate mean within that?
I don't know that it kind of to like essentially decide, right? To decide. Power to decide, power to adjudicate.
So then when we say like that, in other words, I'm not trying to be Weasley here. I'm just trying to get a basis. So in other words, case brought before the court's ability to adjudicate it is basically to render a decision. Do they have the jurisdiction?
The power. The power to render a decision.
Okay. And so I guess a lot of this is then going to hinge in both definitions on the word power.
Yeah, potentially, but I just want to know: is there a premise you disagree with in my argument?
I disagree with premise one and premise two of your argument. Yes.
Okay. Why do you disagree with premise one?
Well, I think it's important to hash out the definition. It's fine. I'll get to why I disagree with them.
Well, if you don't know what I mean, if you don't know what I mean by it, how can you disagree with it already? If you don't know what I mean.
Well, because like when we get further into the debate, and I'm going to say, like, I'm not trying to sandbag or anything. The Supreme Court said there was a decree issued, correct, by Boseberg in the form of a TRO.
A decree? Yeah, there was a TRO issued. Yeah.
So there was an adjudication. There was a TRO, correct?
There was a TRO, correct?
Okay, and the Supreme Court said, no, that's null and void. You don't have the power to issue that.
No.
Yes, that is what they said.
Okay, but that first of all, that doesn't have anything to do with the argument. What does that have to do with my
argument? It does, because that would prove that Boseberg lacked jurisdiction based on both of your definitions. He did not have the power to adjudicate this case. He did not have the power to issue a decree or decide it.
Sorry, so I'm not seeing how that addresses any of the premises.
But
So,
that's
so
why
why
I'm
does that
saying
address one of the premises?
that my argument is, given once we have a definition of what jurisdiction is, I've conceded your definition. Based on your definition, Boseberg doesn't have jurisdiction. The Supreme Court said he does not have the power to adjudicate. He does not have the power to issue this decree.
You're not addressing
Therefore,
my
he didn't
argument.
have- Because
So
what I'm saying is this argument supersedes yours.
But you said we'd start with my argument.
Well, we can.
I'd like
but
to do the argument.
I will get into your argument, but do you acknowledge that based on your definition that you've given, you've already lost the debate that Boseberg didn't have jurisdiction?
No.
Why?
No, I have no. But I would like. Are we going to start with my argument or not?
Okay. Well, so
Okay.
So premise one. You want to start with premise one?
Yeah, sure. If habeas territorial jurisdiction, if the habeas territorial, sorry, I'm going to present it so that can I share my screen so you can see it? Let's
I
see.
think you should be able
Present.
to. Yeah.
Yeah. 1 sec. Let me just do this.
I think I've made my case already and won the debate in like 3 minutes, but
You're just declaring victory without addressing
well, I mean,
like an argument? Yeah.
I will address your argument, but I'm saying that this argument supersedes. When you give a definition of jurisdiction and you concede that the Supreme Court said that Boseberg didn't meet that definition, then he didn't have jurisdiction.
I didn't concede that. You asked me whether or not he had the court ruled he didn't have the power to do it.
He did.
And I said no.
Oh, that's okay. Then we'll get to that later.
But I denied that. Yeah, but that's your
Well, it's clear he
argument,
didn't. The TRO, they said you don't have the authority to issue that TRO.
I don't take that to be what power means, but just give me a second.
Hence me saying it's going to hinge on the word power, because I knew.
Yeah, no, but that's not my argument. That's not my argument. That's your argument. Okay. So you're not going to be able to see this because I'm not able to share my window.
It's perfectly fine. Is it fair to say that you're going to link some things that were on your X thread? So if I go to your X thread and show it to my audience, would that basically be the same thing you're doing?
Yeah.
Okay, let me see if I can do that.
I'm actually just showing the thread.
Okay, because I think it would be fair for my audience to be able to see what you're presenting. Even if I could see it, some of them may somehow be convinced that you won an argument. So it's only fair to try to get
So it's the second tweet there.
Okay, so we are at.
Oh, perfect. Yeah, you're able to show it. Yeah.
You can see it. Yeah, you can see it in your screen. So we're at argument. Argument. That's
premise one.
Okay, premise one.
Yep. So if the habeas territorial jurisdictional rule is a venue rule, then it is not a jurisdictional rule. That's H implies, not J. So do you disagree with that premise?
Yes.
Okay. Why do you disagree with that premise?
Okay. So do you want me to give all the reasons I disagree? Or do you want me to just start with one and then give you a chance to respond?
Let's start with one, yeah.
Okay. One, all lack of territorial jurisdiction cases will also be wrong venue, but not all wrong venue will be lack of territorial jurisdiction. In other words, the cases that you cite and the concurrence that you cite will talk about how because of a lack of territorial jurisdiction, it's venue. That's true. Any court that does not have the authority to hear an argument based on or adjudicate or have jurisdiction based on territorial jurisdiction will also be a wrong venue issue. But not all wrong venue issues will be a lack of territorial jurisdiction. For example, let's say that I am in the state of Texas and I have some case where I'm sued civilly. The entire state of Texas's civil courts would have jurisdiction to hear my case. However, it may be the proper venue to have it to be towards the court that is closest to my location or the location of the crime. In other words, there is a difference between territorial jurisdiction and venue. However, if you don't have territorial jurisdiction, i.e., it is a crime that takes place in Zimbabwe and the United States courts do not have territorial jurisdiction, that doesn't necessarily, that's a jurisdiction issue, not just a venue issue. So even if you're correct,
go ahead. Yeah.
So even if you're correct that not all venue issues are jurisdictional, that wouldn't apply here because we're talking about something that's beyond venue. It's territorial jurisdiction.
That's not part of premise one. So premise one is if the habeas territorial jurisdiction rule is a venue rule, then it is not a jurisdictional rule. That is a venue rule. If this territorial jurisdiction rule is nothing but a venue rule, in the sense that it is just a venue rule, then it is not a jurisdictional rule, right?
But my argument is it's not nothing but. Territorial jurisdiction can be beyond just venue.
Okay, that's premise 2, though. So I'm asking if you agree with premise 1.
No, I don't. The reason is because you added language there. You said if it's only a venue rule. I don't think it is only a venue rule. So it could be a venue rule and more.
Okay, so if the habeas territorial jurisdictional rule is a venue rule and only a venue rule, that's what I meant by the term is a venue rule, to the exclusion of other things, right?
Okay, that's not what you literally wrote.
Rule.
So you can't
No, that's what I'm telling you. That's what I meant, right?
Okay.
It's a venue rule. So if the habeas territorial jurisdiction rule is a venue rule, and it's only a venue rule, then it is not a jurisdictional rule. Agreed?
But I disagree because I have other reasons to reject the premise. But I'll admit that my argument here is more for premise 2 than premise 1. Would you like to get to the next argument? Then? We could readdress this argument.
I want to either grant or not grant the premise 1.
No. That's what I meant. The next argument on this premise. So we'll table my first argument for premise 2. We'll deal with it then. Fair enough? Okay. Other arguments against premise 1. It literally says jurisdiction, territorial jurisdiction. If there is no territorial jurisdiction, there is no jurisdiction for the court to rule, even if they have subject matter jurisdiction. And so the argument that you're making of if it's venue, it's not jurisdiction is nonsensical. It uses
Is it logically possible for the term for this term habeas territorial jurisdiction to not mean jurisdiction? Is that logically possible?
No. They would have used a different word.
Are you serious?
Yeah, they would have said territorial venue.
What do you mean they would have? Words can represent whatever you want them to mean.
No, I'm saying
these are just words, right?
So no, it's not. It's just words. It is called. Sorry, my mic bumped out. It's called territorial jurisdiction because it is a jurisdiction rule. To then what you're doing here is what you'll do is you'll have a bunch of judges that have adjudicated, authors that have interpreted adjudications, etc., that are all one step away. So you're making a chain of arguments. If person A says, then person B says, then person D says, then person E says. The problem is there's going to be little things lost in that entire chain. Everything that you're saying, we'll get to this, is going to be hinged on one thing, and that's the Kennedy concurrence. And the problem is it will, and you'll see why. The problem is the Kennedy concurrence isn't looking into what these other authors or cases that you're talking about that you're going to cite when it references venue. For example, one of the first cases that you cite talks about venue. It is a person that it says has conceded to the jurisdiction of a court, the subject matter of or the personal jurisdiction of a court, based on the fact that they lived and had a business in Delaware. However, that concession to that personal jurisdiction isn't a concession to venue. And so you're using that to say, aha, there is a difference between venue and jurisdiction. But that's not the type of argument that Kennedy's looking at when he says, I think that territorial jurisdiction is a venue argument. Kennedy is clearly using the term jurisdiction as a term that, much like Boseberg did and you, conflating it with subject matter jurisdiction. And we could go through the Kennedy concurrence. He continually says that he's saying, look, we're not saying they don't have subject matter jurisdiction. Territorial jurisdiction is an issue of venue, but not only an issue of venue. Kennedy is never saying issues of venue are non-jurisdictional. He never says that, not once. And the idea that why would I'll finish up with this. Why would the court in this case that cites this blatantly as territorial jurisdiction, why would Kennedy, that's concurring with that and is talking about some quibbles that he has, he agrees with the case, but he wants to delineate himself. Why would he never just flat out say, look, these courts still have jurisdiction? When he's using terms like, he never says that. He doesn't say, well, because it's venue, that means the courts still have jurisdiction. Instead, he says, because it's venue, the courts still have subject matter jurisdiction.
Yeah, I don't see how that's responsive to the very narrow question that I asked, which is it logically possible for the term habeas territorial jurisdiction rule to not be a jurisdictional rule? Is that logically possible?
It would not be called jurisdiction.
What is the contradiction entailed by having a term means with a couple words that are the same mean a different concept than a different word? Why is that logically impossible?
would you say that the word territorial is a descriptive word on the word jurisdiction?
I take that to be a question. That's not an answering. That's
Okay,
not
then
answering.
I'll
That's a question.
answer. The word territorial is a descriptive of the word jurisdiction. Therefore, it is still a jurisdiction. It's
No,
a
but
type
they
of
can refer to different.
jurisdiction, but still
They can refer to
jurisdiction.
different concepts, right? So habeas territorial jurisdiction. It's not necessary, right? That term is a subset of jurisdictional. Agreed.
No, it definitely is. Or it wouldn't have used the word
So
jurisdiction.
why?
Give me
Why
another
is it?
example. Give me another example of a term in law.
Why?
Go ahead.
Okay. So the term riverbank, is that a subset of the term bank?
What's this have to do with the term in law?
So this is whether it's a term in law. It's the point that just because a term includes a word doesn't mean that they refer to the same concept or even a subset of that concept, and that seems like a very obvious point to agree with.
Riverbank, for one, I think is one word, correct?
Riverbank is 2 words, I think, but what does it matter?
Okay, so let's say it's 2 words. Yes, a riverbank would be a type of bank, one along a river.
No, but it wouldn't mean bank in as in the term like a financial institution, right?
No, but
so just
but that's not
they
that's
include
not
the same word doesn't mean they refer to the same concept, right?
but that's completely those. Although that word happens to be the same, that's not what we're talking about here. Jurisdiction isn't a completely different concept in this context, no matter how much you want to say, right? Like it is true that we in the English, right? What I'm saying is that no, the fact that it is territorial jurisdiction, it is the word that's descriptive of jurisdiction. It is a type of jurisdiction. To claim no, territorial jurisdiction isn't a type of jurisdiction is not possible. That's laughable.
Well, there's such things as homophones, right? There's such things as words that mean the same, that are the same word that mean different things.
That's true. That is not the case with the word jurisdiction.
Wait, why? You yourself say that jurisdiction can mean many different things, and so how can it be the case that the terms have to be subsets of each other? It's logically possible for the term habeas territorial jurisdiction to not mean jurisdictional. That's at least logically
it is true
possible.
that different people could use the term to mean different types of jurisdiction, but they're all types of jurisdiction that they're talking about. For example, when you said jurisdiction and you're talking to me, you didn't actually mean the entirety of jurisdiction. You meant subject matter jurisdiction, but that's still a type of jurisdiction. That is what you meant. That's what Boseberg means.
I meant a court's jurisdiction, I take to be broad, but that's not relevant. So what we're talking about is very narrow, is whether terms that include a subset of another term, whether they can refer to different concepts that don't overlap.
No, it doesn't. Not in this case.
No. Whether it does in this case or not, is it logically possible? Is there a contradiction entailed in the word habeas territorial jurisdiction rule being referred to a different category, a different concept than jurisdictional rule? Is it logically possible? Is there a contradiction entailed?
There is a contradiction entailed. In fact, can you show me then give me the Black's Law dictionary of the term jurisdiction that you're referencing?
Why would I need to do that? Why would I need to do that?
You just said that jurisdiction might mean more than one thing. Then give me the definition of what it means.
Is it logically possible for it to mean different concepts?
It is entirely possible, like the word bank, that we could have a word that means different things. There is no explanation. That vast majority of words, that's not the case. For example, if I said the word hat, hat is hat. We have an understanding of what hat is. Theoretically, could I say hat and actually mean shoe? I guess that's theoretically possible. But we would say when it comes to sort of our vernacular, and in this case, when it comes to the legal system, we would reject outright that sort of absurdity, saying, well, words could mean whatever you want them to mean, and therefore we could say that there doesn't need to be a stable definition. Now, I'll ask you a question. Can you provide me Black's Law Dictionary, Columbia Law Journal, Supreme Court, any definition of the word jurisdiction that means something markedly different than what the definition you've already given was?
Yeah, so I provided, if you scroll down, and I shouldn't have to answer this question because you haven't answered my question yet.
I did.
I just want to be clear. But let's go down. If you go down to side note, I kind of predicted that we would go into this.
Side note, okay.
It's and I say side note because it's not relevant to the argument, but because we're stuck here. You see definition 2, territory over which a government, one of its courts or one of its subdivisions has jurisdiction. That's different than jurisdiction. So one of the
It's
definitions
still
of territorial
the
jurisdiction
but-
is very
wait.
clearly not overlapping the definition of jurisdiction.
No, it certainly is, because it's saying the territory over which it has jurisdiction. So it uses the word to define itself. What's jurisdiction?
Whether it uses
let me finish, please. Let me finish. I assume this definition was from Black's Law as well.
Yeah, it's from Black's Law.
Okay, so in this definition, it uses the term jurisdiction. So I would assume by the term jurisdiction that it uses there, it means the aforementioned Black Law's definition of jurisdiction, correct?
It probably refers to one or
Okay, so
yes,
then
yes,
again, once more, this defaults to exactly what I said. Territorial is a descriptive term of the type of jurisdiction.
No, but
yes, that's exactly
you're not getting
what
it, right? So for example, for example, if there were a term that said fish jurisdiction, and the definition were territory over which fish travel, you would not say that that fish jurisdiction is a subset of fish, right?
No, it would be the subset of the jurisdiction.
No,
It's just descriptive of the word jurisdiction.
Okay, just because the definition that it says territory over which fish travel, and I'm inventing this term fish jurisdiction, it uses the term fish. It doesn't mean that the term fish jurisdiction is a subset of the term fish.
That's correct. It's
right?
the subset. Fish is the descriptive of jurisdiction. So it is a subset of the type of jurisdiction.
No, but in that example, fish jurisdiction is not a type of fish. Agreed?
Right. It is a type of jurisdiction.
Okay. So just like here, territorial jurisdiction under that definition is not a subset of jurisdiction. Fair?
No, that's absurd, because what you've done is what you did was you switched the order of the words. For example, let's say I said there is a fish called a jurisdiction fish. And the reason it's called a jurisdiction fish is it looks like a judge. And so they called it jurisdiction fish. Would that be a type of fish?
A jurisdiction fish. I'm not following. Sorry. So the definition is
a jurisdiction.
So jurisdiction
fish. It's a type of fish. It looks like it wears a judge's robe. It's black with a collar.
Okay, got it.
Would that be a subset
of
a type? It would be a type of fish, just like a fish jurisdiction would be a type of jurisdiction. And so a territorial jurisdiction is a type of jurisdiction.
No, hang on. So it would depend. It would depend on the definition, right? So like territorial jurisdiction could be a subset of jurisdiction, but it need not be if one of the definitions doesn't it isn't a subset of it, right? So like,
but you can't provide that definition.
Yes, I just did.
No, you didn't. And furthermore, the only definitions that we should be looking at are those that are applied in the legal context. For example, I could use the word jurisdiction to mean things that are vastly different than what jurisdiction means in a legal context. You would agree with that, right?
You could use jurisdiction differently in the legal context, correct? But we're just the narrow point I'm trying to make, Rob, is it is logically possible for territorial jurisdiction under the habeas statute, that concept, to not be a subset of jurisdiction. Agreed?
No.
Why is it logically impossible?
Provide me one definition to the case. You haven't given me one example. You have not given me one example of that.
That's not. You're not responding. So that's not a response. So you said it's logically impossible. So it's your burden to show what the contradiction.
Again, I've given the caveat for why it wouldn't be logically responsible, in that we could say that any word means anything because they're all human constructs. So I could theoretically say hat means this thing that I wear in my head, and I could say pirate's hat. Well, that's a type of hat. That is
okay. So is it logically possible for?
What I could say when I say pirate hat, I actually mean shoe, and you would say, therefore it's logically possible that pirate hat isn't a subset of hat.
Why don't you just grant it? Yeah, it's logically possible for habeas territorial jurisdictional rule to not be a jurisdictional rule.
What I said is, yes, in that theme of things, of the absurdity that any word could mean anything, then yes, you could say that it would be possible. However, the idea of logic sort of goes out because it makes human communication impossible, because we have an understanding of the words we're using right now, right? That's how we're able to have this conversation.
Yeah.
And if you're hinging on that, actually the courts didn't say Boseberg didn't have jurisdiction because territorial jurisdiction may hypothetically mean something that's not a type of jurisdiction, and you're unable to provide any evidence of that, and just saying, well, we're just saying that hypothetically it's possible if words could mean anything, that it doesn't mean a type of jurisdiction.
Well, just grant it. I don't know why you're
very poorly in the debate.
You're just medding right now, and you're just like signaling to your audience. What
I'm not medding. You're relevant to. You're making an absurd point. You're deflecting to an absurd point because you know that you don't have an argument here. That's like, well, words could mean anything. Yeah, okay, but that doesn't make it logical to
you talk to
acquiesce.
So I'm trying to make you grant premise 1 and you're fighting me on it, right? So this is why it's relevant, right? So I'm trying to make you grant premise 1. The first
but
thing
I
that
don't
you
grant
said,
premise 1. That's what I'm saying.
I know you don't. I don't know why you're so anti. Like, I know you don't grant premise 1. That's why we're working through the arguments. The first argument you said is, well, it could be a venue rule and something else. Well, I clarified what my language meant was a venue rule and only a venue rule. So that argument went away, correct?
Sure. That argument will still apply to premise 2, though. But sure. For premise 1,
sure.
Sure.
Yeah. Okay. Sure. But we're not there yet. But then the second thing you said was it's impossible for habeas territorial jurisdiction because it includes the word jurisdiction in it for it not to be a jurisdictional rule. And I asked, why is that impossible? And you're not providing a contradiction. Why is it impossible for that to be the case?
I just did. The only argument you have against is theoretically it's possible because words can mean anything.
Well, wait. Do you agree with that?
I already answered this. Although theoretically that could be possible that words mean anything. If that is what your argument hinges on, then this entire conversation is irrelevant because we have an understanding that these words mean something. The truth is that although words could mean anything, in the way that we communicate, and in particular in the legal field, we can't accept that words can mean anything. We have to put.
Well, this is a conditional. Yeah. You shouldn't fight me on. So where you're going to fight me on is premise 2. But like on premise 1, it's if the habeas territorial jurisdiction is a venue rule.
Give me
if it is the case.
If you're right that it could be that territorial jurisdiction could mean anything else.
Habeas territorial jurisdiction rule. So that's the whole term. It's 4 words. Habeas territorial jurisdiction rule. 4 words. So if the habeas territorial jurisdiction rule is a venue rule and only a venue rule, then it is not a jurisdictional rule.
Okay.
And
so just to be clear, then you're conceding. Yeah. Would you concede then that territorial jurisdiction is jurisdiction?
That's not relevant to the argument.
But
so why would I
concede that? It's not relevant. I think it will be relevant. I'm asking the question. It's not up to you to decide whether or not it's relevant. I mean, you just. Well, theoretically, couldn't hat mean shoe? I don't think that's relevant.
Yes, hat could mean shoe.
Okay, so then why are you?
No, but you brought up that it was logically. You said it was impossible for habeas territorial jurisdiction rule to not be a jurisdictional rule. Why can't you answer
the question? Is territorial jurisdiction?
Well, I don't see why it's relevant.
Can you answer the question?
It could be, but it could also not be. Is the answer?
Okay,
it's not relevant, but I'm answering it.
Can you explain how it could not be?
Yeah. So if you're using territorial jurisdiction as in the Black's Law Dictionary to refer to geographic space, that is to say territory, then it wouldn't be a category of jurisdiction. That's what I said side note of. It's not relevant. And in fact, I predicted you would bring it up.
Okay. Then why did you just say it was
jurisdiction? It's geographical
space.
Why
didn't you just answer instead of just say it was irrelevant?
Because I don't want you to fixate on it because it is actually irrelevant. But I predicted that you would go down that route. And that's why I put side note there.
Okay. So 2 things on this. First, let's talk about, notice that there's 2 definitions that Black's Law gives. You've highlighted the second. Let's focus on the second.
This is irrelevant, right? It's irrelevant.
It is not irrelevant. It is not irrelevant, right? Because if I could prove, you tell me, if I could prove that court, what was the term you used? Habeas territorial jurisdiction rule. Okay, if I could prove to you that the habeas territorial jurisdiction rule is a territorial jurisdiction rule, that it is one, then this wouldn't be irrelevant, correct?
No, because you would have to show. That would just ground out into wait. So that would just ground out into premise 2, which is it's a jurisdictional rule because it's a territorial jurisdiction rule, and then we could have the debate there. But that's not what we're talking about. Premise 1.
But you would concede if I could prove that the habeas jurisdictional rule or habeas territorial jurisdictional rule is a territorial jurisdictional rule, then you would say, okay, then this is relevant.
For premise 2, it may be relevant, but only if the territorial jurisdictional rule has to be.
So therefore it's relevant. Yeah. So now let's look at the definition.
No, it's not relevant to premise 1. It's not relevant to premise 1.
It is relevant to premise 1 because what you're trying to get me to grant on premise 1 is that if it's a venue rule, right? But if it's a territorial jurisdiction rule, that proves that it's
this is a conditional. It's if
it proves that it's not only a venue rule.
So in premise 1, I clarified that when I say is a venue rule, I mean and only a venue rule. So if habeas territorial jurisdiction rule is a venue rule and only a venue rule, then it is not a jurisdictional rule. Whether or not what the rule actually is, that's for premise 2. But this is just a conditional.
No, because if we could prove that it's a territorial jurisdiction rule, right, that means it's not only a venue rule.
Okay, but this that does not refute anything in premise 1 because if you can prove that it's a territorial,
it refutes that it's not only a venue rule.
But premise one doesn't say it's only a venue rule. It says if it's only a venue rule. If, then it's not a jurisdictional rule. It's a conditional.
Okay, so your argument is if it's only, you're saying, okay. If it's only a venue rule. And so when I say, wait a minute, I think it's a territorial jurisdictional rule, you're saying, no. I'm just saying if it's only a venue rule. So you want to deal with all this on premise two?
Yeah, well, the stuff that you're talking about is premise two stuff. But but are you conceding that premise one, that if it's a venue rule and only a venue rule, then it's not a jurisdictional rule?
No, I don't think that you've provided evidence to me or the audience that venue rules aren't jurisdictional rules.
All right, so let's go into support for premise one. So I'll refer you to the definition of venue, where it says venue must be carefully distinguished from jurisdiction. Jurisdiction deals with the power of the court to hear.
Where's that? This here that I'm showing?
Yeah, venue.
Okay. The proper from Black's Law again, I assume. Correct?
Yep.
Okay. The proper or possible place for a lawsuit to proceed, because the place has some connection either with the events that give rise to a lawsuit or with a plaintiff or defendant. The territory, such as country or other political subdivision over which the trial has jurisdiction. Okay, so it uses it's using the term jurisdiction.
That doesn't mean that it's a type of jurisdiction.
Okay,
you understand that, right?
What does it mean? What does the word jurisdiction mean? Is it safe for me to assume
it's pointing you to 1 and 2? Wait. It's pointing you to 1 and 2.
Let me finish real quick, and then by all means you can answer. Because this is from Black's Law, when it uses the term jurisdiction here, that would imply to me that it's using the previous defined term jurisdiction that you cited.
And it's actually telling you which of the definitions, sub 1 and sub 2, and I provided both of them for you.
So if the term jurisdiction, according to Black's Law, means, quote, a court's power to decide a case or issue a decree, then we could substitute that in for the territory, such as a country or other political decision over which a trial court has the ability to decide a case or issue a decree.
Yeah, the territory.
Right, the territory. So if it's not the correct territory, then they don't have jurisdiction. The power.
That's not what that says. They're different. So one is. What do you mean? Yes, exactly they're obviously different.
No, it literally, let me reread it. The territory, such as a country or other political subdivision could be like state, district, correct? That's what it means by political subdivision.
Yeah, it could be state, it could be, it's some kind of geographical land.
So let's insert words just so we could have a more clear, the territory, and by territory, what they mean is country, state, district, right?
Geography.
Right. Those sorts of things over which a court has the ability to adjudicate or issue decrees.
Right.
So the venue, if that would imply that if it is an improper venue, it doesn't have the ability to adjudicate or issue decrees. That's why it's using the term jurisdiction.
That isn't what it says. No, that is not what it says. And just to be clear, are you suggesting that venue is the type of jurisdiction? That venue is.
I'm saying, according to the definition you've given here, that yes, if it is an improper venue, then that would mean, according to Black's Law, that they do not have jurisdiction.
Wait. So I just want to be clear. This definition says territory, right? So territory is just land. So it's referring to the term jurisdiction, but it's not jurisdiction. It's land. It's physical.
So
physical
venue
place.
This is what it's saying. Venue is the place, the geographical place that has jurisdiction.
So the physical place. A place doesn't have jurisdiction. A place is just matter. It's dirt and it's houses. And
a place that has the court.
Space.
A place that has the court that has jurisdiction.
The place over which a court may have jurisdiction. That's the second definition. There's two there, but yes, that's one of the definitions.
Okay, so then it would seem
and you'll notice under that there's two leading treaties by leading authors on federal practice that says venue must be carefully distinguished from jurisdiction, and the distinction is obvious, right? So it just isn't the case that venue and jurisdiction are the same thing.
Again, when it's talking about distinguished from jurisdiction, it's talking about subject matter jurisdiction. So if you read it, it says jurisdiction deals with the power of a court to hear and dispose of a given case in a federal system. It involves questions of constitutional decision dimension making a basic court of judicial power among the states and between state and federal courts. Venue is of a distinctly lower level of importance. It's simply a statutory device designed to facilitate the balance of objectives of optimal convenience between the partners The distinction must be clearly understood between jurisdiction, which is the power to adjudicate, and venue, which relates to the place where the judicial authority may be exercised as intended for the convenience of the litigant. So, given this,
next sentence. It is possible for jurisdiction to exist, though venue in a particular district is improper.
Correct.
Agreed?
That's my argument. But that doesn't seem to be what the definition.
Wait. So it's possible. It's possible for there to be improper venue and a court still has jurisdiction. Agreed?
Yes, that's my argument, but that's not the definition. But that's not what your definition says.
Hang on a second. There's nothing about those definitions. So those definitions do imply that they're very different things.
Whether or not this is from Black's Law. Just are you sure it is?
Are you serious?
Yeah, I'm just saying the font looks different than maybe not. I guess
this is from Black. Jesus Christ, dude! It's from Black's Law Dictionary. I can provide you the PDF if you want.
No, it's fine, right? Like, it's if there is a territory, right? If we're saying it's the improper territory to have this case, right? That would be venue, like an improper venue claim, correct?
Mm-hmm.
And this says
that could be one interpretation. Yeah.
What would be another?
Well, that the specific courtroom, right? It could be the case, for example, that there are, several different courts within a geographic location where there's a preference order, even among courts that hold sway over the same territory. So I'm just saying, I'm trying to be as comprehensive as possible. I'm not trying to be slimy and telling you there's a vision of a venue that
I will just tell you
the same
I'm
territory.
Confused because I think that this definition number 2 is a bad one. We haven't got to
whether it's good or bad isn't relevant to the argument.
I will tell you what my belief is and what my argument is, and I've already said this.
Okay.
For me, it is that all times that a court lacks territorial jurisdiction, they would lack venue. So they would also be subject to improper venue claims. However, not all improper venue claims are improper territorial jurisdiction claims. And I gave the example. For example, every criminal court in Texas, if I'm a citizen of Texas and committed a crime in Texas, may have territorial jurisdiction. However, it could be improper venue to charge me in the Southern District of Texas as opposed to the Northern District.
Okay, my argument doesn't rely on your opinion, and I will definitely deal with what you're saying there. I'm not trying to avoid it. I just want to run the argument. And under the argument, this is the support for that premise that the venue rule is by definition not jurisdictional. It is distinct from it, and it's that a venue rule, in fact, can never be a jurisdictional rule. Assuming that what I mean to say is a venue rule that is only a venue rule is by definition not a jurisdictional rule. And but by the way, it's not just that. There's other support for premise 1. Your own lawyer that you talked to in your chat, Mr. Ubercross, says, and quoted in your chat, jurisdiction never means venue. Then there's the Supreme Court case law that says as much. There's follow-on cases from the Supreme Court that says venue and jurisdiction are quite different concepts, that they're not synonymous. Venue concerns the privilege of being held accountable to the court in a particular location. Jurisdiction is the power to act. So a venue rule by definition is not a jurisdictional rule.
No, that's not true. If something's only a venue rule, we might be able to say that.
If something is only a venue rule, yeah. But venue rule,
you misquote, you misinterpret what Mr. Ubercross is saying. Mr. Ubercross is saying, he's basically saying what Pisco will do is try to muddle the debate by confusing his audience as to conflating territorial jurisdiction and venue. And he even just says this now in my chat. If you're interested, he says, territorial jurisdiction. Can we do this to people here? Venue. Is this the best place to do it?
But nowhere in my argument, nowhere in my argument is the term territorial jurisdiction by itself present. So my argument does not depend on the definition of territorial jurisdiction. I'm not conflating or equivocating between venue and territorial jurisdiction. Because nowhere in my argument.
Let's go one more time to your premise, and maybe I'll be willing to move on to premise 2. So you're adjusting it to say if habeas territorial jurisdiction rule is only a venue rule, then it's not a jurisdictional rule. Fine. I guess we'll move on to premise 2.
But do you grant that premise? You actually, in good faith, grant it, and you believe
it. With the word
only,
I think, unless I would think of something later, but for the purposes of this, I truly believe that that's a fair premise for now.
Okay. So the support for premise 2 is the habeas premise 2 is the habeas territorial jurisdiction rule is a venue rule because the Supreme Court said so. And the best example support for this is Trump versus JGG, where it says, quote, for core habeas petitions, jurisdiction lies in only one district, the District of Confinement. The detainees are confined in Texas, so venue is improper in the District of Columbia. Therefore, the habeas territorial jurisdiction rule is a venue rule. That's the best argument. There's more.
Does that say only venue?
So it's the only one that's included there, yeah.
No, it's not. It's specifically, in fact, if you don't mind, I'll share this. Here's what it said. I have this highlighted. For core habeas petitions, jurisdiction lies only in one district, the District of Confinement. That's what the Supreme Court said. So the only jurisdiction, there's only one jurisdiction, one court with jurisdiction. That's what it's saying here. You agree, correct?
It's talking about territorial jurisdiction per the habeas statute.
But what it's saying
it's referring
here is,
to the principle, and it's referring to the habeas territorial jurisdiction principle, the rule.
What it's saying here is that there's only one district with jurisdiction. Any other district wouldn't have jurisdiction. And then it says
it's referring to the territory
in Texas, so venue's improper. Right, but it doesn't say that this is only a venue order. It just it says right before that jurisdictional. It's a jurisdictional order. So it's not only venue.
It's not.
And this was clear what you were going to try to do. That's why adding the word only is interesting, because without that word only, where does it say? Can you show me anywhere in here where it says this jurisdictional rule, what we mean is only venue? Can you show me anywhere where it says that?
Yeah, so it wouldn't have to say that to mean that it's only a venue rule. It wouldn't have to say that. So just you agree that, right? It wouldn't have to say the terms that you're saying for it to only be a venue rule. Agreed?
It would if it's specifically saying that it's jurisdictional like it is here. It would have to say, but it's not jurisdictional, it's only venue. That's what it would have to say. Because just to be clear, just to be clear, what it's doing here is where it says for core habeas petitions, it's quoting Padilla, correct? The Rumsfeld v. Padilla. Yep. So the court's saying, here, we're going to quote this section from this case that we're concurring with. We're saying, yes. So it says in Rumsfeld v. Padilla, jurisdiction lies only in one district, the District of Confinement. Now, if they wanted to say, we, however, do not think that jurisdiction only relies in one. However, venue only relies in one. That's what it would say. It wouldn't just literally quote that there is only one jurisdiction and then say, yep, this means that the venue is improper.
It's referring to the habeas territorial jurisdiction rule, and that, as is evident in Padilla, is not, and as evident in Kennedy's concurrence, is not referring to the standard usage of the term jurisdiction as I'm using it, or as Black's Law Dictionary is using it. And so what it is it's equaling it to venue, right? So it's citing the principle from Rumsfeld versus Padilla, and it's saying because of that, venue is improper. Not jurisdiction's improper, venue's improper.
No, but it already said that jurisdiction's improper, and the specific reason that the jurisdiction's improper is because it's in the wrong court.
Under the habeas territorial jurisdiction rule.
Okay, so then what I'll need you, so then we'll go back.
But because venue's improper.
So then we'll go back to the previous discussion we were having that you said was irrelevant. Are territorial jurisdiction rules jurisdictional rules?
Sometimes.
Okay, give me an example of when they're not.
When it's referring to the territory, physical territory, geography.
Okay, so the territorial jurisdiction rule would say, for example, referring to physical geography. So if a rule says the United States federal courts can only try cases that were committed by or occurred on the territory of the United States, okay? Is that its jurisdiction rule?
I'm not following it. It would depend on an analysis by the courts on whether or not that is understanding it as a physical geography, and that there's a bunch of variables about whether a court would decide it. But what's useful for our purposes here is, in this sense, it is referring to just geography.
Give me the definition. Give me the definition of it. Give me every definition of territorial jurisdiction you want me to look at. Go ahead.
Wait a second. Why is that relevant to my argument?
Because your argument is, but we're focused on, we've already talked about this. Jurisdiction, right? It uses the term jurisdiction. Territorial is a type of the jurisdiction, right? You said that'll be dealt for premise 2. I said, fine. Now we're on to premise 2. Okay. Territorial jurisdiction. That is a type of jurisdiction. Therefore, let me finish. Therefore, if you don't have territorial jurisdiction, you don't have jurisdiction. You say, no, because there could be alternative definitions like hat could mean shoe, et cetera, et cetera. Okay. Give me a definition of territorial jurisdiction that's not jurisdiction.
Yes, territory over which a government, one of its courts or one of its subdivisions has jurisdiction. That's a definition which is not a subset of jurisdiction.
Okay, that would be.
And under side note, I gave you 2 definitions. Of territorial jurisdiction.
So let's start
One
with
which
this. Let's start with
one-
number
oh,
two.
yeah.
The one you just read, territory over which a government, one of its courts, or one of its subdivision has jurisdiction. So what that would mean, the land. So for example, let's say North Carolina. The territorial jurisdiction would be the geographical land of which they have jurisdiction. Okay, if something
That's
occurred
not jurisdiction.
outside,
Agreed?
if something occurred
Oh,
outside
wait,
of
do you agree with that? Do you agree that's not jurisdiction?
yes, that's jurisdiction, correct.
Okay. Well, no, it's not jurisdiction.
Yeah, that is jurisdiction.
Territory,
Because
physical land isn't jurisdiction. Physical land is not jurisdiction.
but physical
land is just physical land.
Physical land is giving the boundaries geographically of where their jurisdiction lies.
Right, but the definition, what territorial jurisdiction means under that definition is simply a set of territory, and it's not jurisdiction.
So the state of North Carolina would be the geographical, like from this longitude to this latitude, that area would be the territorial jurisdiction, i.e. the land where they have jurisdiction, i.e. where they have the ability to.
But it wouldn't be jurisdiction. It would be land
It's describing.
jurisdiction.
It is descriptive, right? It is descriptive of when they have jurisdiction. You haven't given me any explanation of if I say that a place lacks territorial jurisdiction, that wouldn't mean jurisdiction. You haven't given any example.
So
give a definition.
So just because so that definition too refers to a set of territory where it's necessary to know where the jurisdiction is, but the definition itself is not jurisdiction. That must make sense to you.
It is in reference to where they have the ability to adjudicate and issue decrees over.
Yeah, it's defined by jurisdiction, but it doesn't describe jurisdiction. It is not itself describing jurisdiction.
It is saying, right. It is saying that it is a landmass in which they have jurisdiction.
Right. So it's not jurisdiction itself.
Give me,
because
it is so, but it still is descriptive of when they have the ability to adjudicate. Give me, if I said this court lacks territorial jurisdiction, give me a definition other than, oh, what it means is landmass. Because when it says court, let me be clear.
I just want to make sure we agree. Do you agree definition 2 is not jurisdiction?
Let me be clear, right? When a court says, like this court has said, not talking to hypothetical, but like this court has said, the only district is the district of confinement. When it's using territorial jurisdiction in that sense, when it's saying this court does not have territorial jurisdiction, it's clearly impossible that it's referring to a landmass, correct?
No.
Because jurisdiction, territorial jurisdiction.
Let's go back a little bit and just make sure we agree that that second definition doesn't mean jurisdiction. Do you agree with that?
No, it does mean jurisdiction. It's referencing a land, right? Like, so let me phrase this. It is referencing land and not a legal concept here.
Yeah, so it's not jurisdiction. Fair.
Okay, great. And all right.
Now, do you agree?
I agree. Would you agree that any time that any court would say that someone lacks territorial jurisdiction, it would be impossible to mean that they're talking about geographic land because they're referencing the court specifically?
If by possible you mean logically impossible, no, it's not logically impossible.
Okay, would you admit that it's improbable beyond all reasonable conversation to have about it?
No, because in this specific
so the
Supreme Court in the habeas territorial
Supreme Court says you don't have territorial jurisdiction to rule over that, and you think that what the Supreme Court's saying is you don't have longitude 138.8 to longitude. That's what you think they're saying when the court says that.
So in the context specifically of the habeas statute, that's a situation in which territorial jurisdiction is a reference to specific land areas, and because the courts have interpreted it to be a venue rule, and so it absolutely is the case that when the habeas statute refers to respective jurisdictions in sub A of the habeas statute, that they're talking about the land mass, not the power to adjudicate.
That's not true. Can you show me where that is? Show me anywhere that you have where that is.
Wait, where what is? Where
you just said when the courts.
Statute?
So does it say that in Kennedy's concurrence? Does Kennedy's concurrence say that this is venue, it's not jurisdiction?
So Kennedy says, quote, citing Moore v. Olson, suggesting that the territorial jurisdiction rule is a venue rule and the immediate custodian rule is a personal jurisdiction rule.
Okay, well, that's that.
And
you
he
realize
goes on and
that
says
line,
this approach is consistent with the reference in the statute to the respective jurisdictions. As we have noted twice this term, the word jurisdiction is susceptible of different meanings, not all of which refer to the power of the federal court to hear a certain class of cases. The phrase respective jurisdictions does establish a territorial restriction on the proper forum for habeas petitions, but does not of necessity establish the limitation goes to the power of the court to hear the case.
right? So it's territorial. In other words, if you're not within that territory, you can't hear it.
No, Kennedy's literally saying it doesn't go to the power to hear the case. And that's the definition of jurisdiction. That's the definition of jurisdiction.
When he says territorial restriction, what does he mean by that?
He means that it's a boundary of where venue is proper, is within a
so outside of that venue,
boundary.
Outside of that boundary, then it would be improper.
Outside of that territorial boundary, venue would be improper, correct?
Okay, so then when he's referring to territorial jurisdiction, he's referring to jurisdiction within the geographical location.
No, he's referring to a geographical space, and
correct.
That's what he's referring to, geographical space.
Right, so for example, the geographic space, in this instance, the space of confinement, correct? The geographical space would be, with the habeas petitions, that the only jurisdiction is the area of confinement. So that would be the geographical limit. Anything outside of that geographical space.
That venue is proper in the territorial jurisdiction of the court. That is to say that.
Right. In fact, the territorial jurisdiction is what it's talking about specifically is the geographic area of which they have jurisdiction. That's what territorial jurisdiction means.
The geographical area over which the district court has jurisdiction. Right. The geographical area.
And by jurisdiction, we mean their ability to issue decrees, to adjudicate cases.
By jurisdiction in that sense, it's probably referring to the power to over which to hear a case. Although it's probably a little bit more narrow to the broader definition of basically the range of geographical area over which they're designed to sit over. So for example, the Southern District of New York sits over a bounded geographical space by statute, and that includes Manhattan, it includes other places. So whatever that bounded area of jurisdiction is under the statutes, under the law.
Correct. And so what is being said here is that outside of that area of confinement, that the territorial jurisdiction is the area of confinement. That's the jurisdiction, the district court there. Outside of that, there is no territorial jurisdiction.
There's no venue. Outside of territorial jurisdiction.
There is no jurisdiction. There is no. Yes, because
but the Supreme Court told us, right?
Is Kennedy? Let me finish. Is Kennedy saying, for example, well then in Padilla, because they're referencing Padilla here, right? Is he saying, well, it would have been proper, even though he was? I don't remember exactly where Padilla was confined. Let's say Texas, just for the sake of it. It doesn't matter.
He was confined in some I think it's some northern state somewhere, but they tried to bring it in New York.
Right. So is he saying that they could bring this in New York? Is New York have the ability to adjudicate this case?
So it's improper venue for to bring a case in New York,
That's
but they could if the government waived it, right? They could bring it in New York. So it's
but the government didn't waive it, and Kennedy specifically says
the government didn't waive it, but that's one of the reasons why you one of the clues and what one of the definitions, or at least the treatise he suggests, is that distinguishes jurisdiction and venue here.
Nonetheless, Kennedy is quite clear. He goes on. Right. He's quite clear that says, look, none of the exceptions apply here, though. Right. Government didn't waive. And so the only proper venue, the only proper jurisdiction.
Agreed. Proper venue.
OK, but when he's saying venue, he's implying that every other venue would not be allowed to hear the case, i.e., based on the
still venue.
But wait a minute. You just said when we asked what the definition of jurisdiction was, it's the ability to hear a case and issue a decree and decide it. You're acknowledging. I just want to get what you just admitted there.
Yeah.
You're admitting that Kennedy says that without all these exceptions, which neither the Padilla case or the Boseberg case has, without that, the only court that could hear it, the only court that could adjudicate,
the only court that has proper, only one court has venue. Only one court has venue.
But
correct.
You're inserting the word venue there. The only court that could issue decree and adjudicate. Is that fair?
No.
What other court can do that?
Other courts. A court in which the government has waived venue.
Okay, so only if they waive venue. That's the only exception?
That's what I mean. That's why it's venue. It's not jurisdictional. So
No.
But in the main, it's possible for only one court to have venue. It's not an issue.
But if we said that the definition, we have both agreed what the term jurisdiction means. We've both agreed, correct? We are saying for the purposes of this debate, and what we truly believe is that jurisdiction is the court's power to decide a case or issue a decree. Did any court other than the District of Confinement have the ability to issue a decree or decide a case?
Yes.
Which?
Yeah, if the government waives,
but they
can't do with jurisdiction.
But they didn't.
Yes. Yeah.
Okay,
so it is the case that only one court has venue. Venue is only proper in one court.
You keep inserting the word venue. Did any court? There was. You can say rule. If. We're not talking about if. A lot of things could be if. Right? We could say
in this case, the only proper venue was Texas.
We could say that a case where the court doesn't have subject matter jurisdiction, you could come up with hypothetical and say, well, they would have subject matter jurisdiction if, but that's sort of irrelevant to what we're talking about. We're not talking about the hypothetical. We're saying with what actually happened in both the Boseberg
in this actual thing, only one court had venue. Venue.
We're not talking about the word. Take the word venue out of your vernacular.
Why?
How many courts, without the exceptions, without the hypotheticals, how many had the authority to adjudicate and issue a decree on this case?
All district courts in the United States.
That's not true. Then why did they overturn the Southern District of New York doing it?
In Padilla, or are you talking about the Boseberg
yes, in
case?
Padilla or in Boseberg? Why did they overturn the TRA for Boseberg? If they had the ability to do it,
because venue was only proper in one state, in one court.
But again, you're begging the question. You're assuming, if venue's improper, it's not a jurisdictional question. And I'm saying, but it's not just venue, it's more.
That's by definition, Rob. That's by definition, Rob.
You can say that's your definition, but your definition of jurisdiction.
No, that is by definition. So all these other courts.
Your definition of jurisdiction supersedes it, right? You've already given your definition of jurisdiction. You said that jurisdiction is the ability for a court to adjudicate.
Yeah, venue doesn't get to the power.
So take out the word venue. Take out the word venue just for a second, right? Okay. Were there any other courts in Padilla that had the ability to adjudicate or issue a decree as this case stood? Could the Southern District
of New York, ability, do you mean power?
What I'm saying is, if some other court would have said, we want to rule in, like the Southern District of New York, would the Supreme Court said, yes, you can, or no, you can't?
They would say, no, you can't.
Okay. What about Southern District of Columbia? Would they have said, yes, you can, or no, you can't?
Southern District, there's no Southern District of Columbia.
District of Columbia Court.
Yeah, they would say you cannot rule on this case.
What about a district court in North Dakota, South Dakota, North Carolina, South Carolina?
You cannot rule on this case. You cannot rule on this case.
Can you name one other court other than the area of confinement that had the ability to adjudicate or issue a decree on this case?
Yeah, so the only place which could rule on the case was either the Southern District of Texas or one of those cases, because that's the only place where venue was proper.
It doesn't matter. So that's the definition of jurisdiction. So only one court.
No, it's not.
Yes, you gave the definition of jurisdiction. Do you want me to read it again? Yes. Let's read. Okay, let's read what your definition was again. Your definition is
a court's power to decide a case or issue a decree.
Right, a court's power. Did the court have the power? Did the Southern District of New York have the power to issue a decree?
Yeah, but that's a term of art. A court's that refers to a bunch of case law that delineates between what is and the inherent power of the court versus what is not related to what's related to convenience, and that grounds out into the case law of the country. And so
that's not true.
It is. Yeah.
Provide the definition, the legal definition of the term power.
Yeah, so that's provided in the case law, which is further elaborated, right? So we can keep doing the kind of reductio ad absurdum, but there's a scope of things, a scope of legal concepts that relate to power to adjudicate, and a set of things that don't relate to a power to adjudicate, and those categories are decided by the case law. And so the case law says this type of stuff relates to the power to adjudicate, and this stuff doesn't relate to the power to adjudicate. And so I refer to the case law that informs what refers to the power to adjudicate, and that venue is specifically not the power to adjudicate.
Because the power, it shows when you go to the case law, what the case law, including what the Kennedy concurrence says, is when they're saying power, they're saying they literally, it is improper, they can't do it. That's what it's saying.
So taking you, so if that's the case, you agree any dismissal based on venue is the dismissal based on jurisdiction.
No.
Agreed?
No.
Wait. So then how would that be, using your definition of power there, if a court lacks venue, it lacks jurisdiction. Agreed?
Because no. Let me explain why.
Why?
Right.
Give me one instance under your explanation where
sure.
it'd be improper venue and
I commit a
jurisdiction.
crime in Texas, right?
Mm-hmm.
I commit it in southern Texas, in the Southern District of Texas. That's the geographic location.
Mm-hmm.
However, jurisdictionally, the territorial jurisdiction, all courts in Texas have the territorial jurisdiction to hear it. So I get rung up in a northern district in Texas. That could be jurisdictionally, they have the power to issue, but for convenience and for venue.
No, but they can't rule on it, right? But they can't rule on it, right?
Of course
they can't rule on it.
Of course they can.
Why can they? But if venue's improper, they can't rule on it, right?
No, they still can.
How can they?
Because they could rule on it because they have the jurisdictional ability to do it, right? It's just
okay. Same here.
No, it's not the same because they don't have the jurisdictional ability. Only as the court says, it's very clear. Only one district has jurisdiction, the District of Confinement.
Yeah, so is the difference that
it does not say only one district has venue.
So the difference is, so in your venue example where you did a crime in Texas and a court dismisses for improper venue in one district of Texas, you would say because let's assume there's only one case in which venue would be proper in that criminal context, and that's in the Southern District of Texas. So in that hypothetical that I've just provided, only one court, that is the Southern District of Texas, venue is only proper there. But the DA tries to bring it in Northern District of Texas, and they say nope, and venue is improper. There's only one place where you can try the criminal case. It's in the Southern District of Texas. Would you agree there that it's a dismissal based on jurisdiction? The court doesn't have the jurisdiction to hear the case in the Northern District of Texas.
No, because the law in Texas will say that jurisdictionally they have the ability to hear it. Venue is more of an issue of convenience.
Yeah, that's what's going on here.
No, there's only one jurisdiction. It's not just
in the Texas example. There's only one jurisdiction too, Southern District of Texas.
No, that's not true. The law in Texas will say that all of the courts in Texas have the jurisdiction to hear this case, but the best venue would be the venue that was closest to where the.
That's what's happening here.
That's not.
That's
true.
What's happening here.
It says specifically the opposite. It says for core habeas petitions, quote, jurisdiction lies only in one district.
You keep repeating that. I'm telling you that's a reference to territorial jurisdiction. That is to say geography, and it's for venue purposes. That's what the courts have interpreted as, including the Supreme Court. But what I'm talking about here is what I'm doing here is I'm trying to get you to acknowledge that there could be a situation in which only one court has proper venue, and every other court in the United States is going to dismiss for lack of venue, and those dismissals wouldn't be jurisdictional. They would be based on venue. Agreed?
Please repeat the question. I think I misunderstood.
Yeah, sure. So there are situations in which only one court is the proper venue. And if you try to go to every other court, let's say in Texas, and they dismiss it because there's only one place you can do it, and that's in the Southern District of Texas because that's the only place where there's proper venue. The defendant, if he wanted to, he could waive it, but he hasn't. So you have to go to the Southern District of Texas. In that situation, all those dismissals would not be jurisdictional. You wouldn't say that the Northern District of Texas lacks jurisdiction. You would say the Northern District of venue is the Northern District of Texas is improper venue.
In that sense, if the other cases had jurisdiction, but they were deemed to be improper venue, I would say they had jurisdiction but lacked proper venue.
Yeah, that's what's going on here.
That's not what's going on here. Again, their words matter. The difference is they specifically say only one jurisdiction that lies only in the District of Confinement.
Yeah,
they would have said,
why didn't territorial jurisdiction?
Why didn't they say venue?
They do. So right after they say they clarify what they mean. So right after that sentence, they clarify what they mean, and they say for core habeas petitions, I'm reading both sentences. For core habeas petitions, jurisdiction lies in only one district, the District of Confinement, citing Rumsfeld versus Padilla. The next sentence, and I notice the word choice here, the detainees are confined in Texas, so venue is improper in the District of Columbia. That's right, them signaling it's venue.
They're saying it's venue, but they're saying that the venue, and because it's an improper venue, it's also an improper jurisdiction.
But that doesn't follow. We know that.
It does follow. That's why they use the term jurisdiction in the Padilla court.
No, but that's a reference, as Kennedy lays out, to territorial jurisdiction.
Right. Territorial jurisdiction, which we've already given the definition of, is about
one of, but in the geographic sense.
No, it's not in the geographic sense. It's saying that outside of that geographic area, you don't have jurisdiction. In this case, what the court is saying is that there's only one geographic area that there is jurisdiction. That is the area of confinement. All other jurisdictions don't have jurisdiction. All other courts
but
don't
the Supreme
have
Court is telling you, that the jurisdiction for purpose of habeas, that's what the court is telling you, is venue, right? The conclusion isn't the detainees are confined to Texas, so there's no jurisdiction. It's the detainees are confined to Texas, so venue is improper. They use their choice. The word choice is purposeful. It's that's what I say.
From the decision, right? Not the concurrence, but the decision. District courts are limited to granting habeas relief within their respective jurisdictions. We interpret this language to require nothing more than the court issuing the writ have jurisdiction over the custodian. Thus, jurisdiction over Padilla's habeas petition lies in the Southern District only. And if it has jurisdiction over Commander Marr, we conclude it does not.
So so if you go to footnote 7, it clarifies what it means by jurisdiction. And what it means by jurisdiction is in the territorial jurisdictional sense. That's what it means.
It says
7.
The word jurisdiction,
the majority of this court.
The word jurisdiction, of course, is capable of different interpretation. We use it in the sense of the habeas statute, not in the sense of subject matter jurisdiction. So it's saying we don't mean subject matter jurisdiction, right? But it still means jurisdiction.
It means jurisdiction in the habeas statute sense, and jurisdiction in the habeas statute sense, as the 2025 per curiam decision makes clear on page 2 of the per curiam decision in this court under this term with Chief Justice Roberts, it goes from Padilla to venue. So the Supreme Court under this court is making clear what it's meaning. It's venue, right? So the habeas statute is what Padilla is mentioning, the sentence after that is so venue is improper. That's what they're using. Come on.
So, and not only, you're also, I just want to say, you're doing something very slippery as well. Is that what it says? It's just venue? Is that what the concurrence says?
So the territorial jurisdictional rule is just venue. The immediate custodian rule is personal jurisdiction, but that's not an issue in the Trump versus JGG case.
Why wouldn't it be?
Because it's not part of the holding of the Supreme Court, because nowhere does the custodian personal jurisdiction issue come up. So it's not referencing the immediate custodian rule. And so that's not what's at issue. That's also
what it's saying is because it's the American. So what you're saying there is the immediate custodian, right? A question of you're saying that refers to the person.
Yeah, the Supreme Court didn't touch that issue. The Supreme Court is not interpreting or applying personal jurisdiction. It's implying venue. That's why it says, so venue is improper. They're not talking about the custodian. They're talking about the venue.
But with personal jurisdiction, it's saying specifically that in order to have personal jurisdiction, let's backtrack for a second. Can you define personal jurisdiction for me?
Sure. I don't know why it's necessary, but I will pull it up. I prepared it just in case you would bring it up. So just give me a second to pull up my notes. Under Black's Law Dictionary, a court's power to bring a person into its adjudicative process. Jurisdiction over a defendant's personal rights rather than merely over property interest is another. And I guess I'll tweet additionally to show you. Here, I'll at you as well. So this is personal jurisdiction at Rob Norm. I prepared this just in case you would bring it up. So let's do this. Oops. Boom. And then I'll retweet myself as I am wont to do. Personal jurisdiction.
So what are the things that would be necessary for a court to prove that it has personal jurisdiction over a person?
So it depends. So now this is 1L civil procedure. There's the principles under Pennoyer versus Neff, the traditional bases of personal jurisdiction. And those will include things like presence in the state, domicile in the state. But the court has expanded what counts for personal jurisdiction, including, the doctrine from International Shoe, and that doctrine relates to minimum contacts analysis. So if certain contacts are sufficient to give rise to a claim, and that's sort of been elaborated in numerous cases. This is like all 1L law stuff, is beyond just physical presence test. And so, personal jurisdiction is not just about presence in the state, or tag jurisdiction is another one where if you're in the state and you issue a summons to someone or something in the state, that's just one way to get personal jurisdiction, but you can do, a domicile.
So you either have to be domiciled there or you have to have a certain specific context.
Minimum context analysis is the
Okay, so in order for there to be personal jurisdiction here for Boseberg to have ruled, what would he have to prove?
Why is that relevant? It wasn't an issue of the Supreme Court.
In order for Boseberg to have jurisdiction, would he have to have personal jurisdiction?
So I actually think that the answer is no to that, because I think that personal jurisdiction is waivable and doesn't have to go with the inherent power of the court. But I'm more ambiguous on that. The answer is I have to do more research on it. I don't see how that's relevant to our discussion, though.
So if your argument is that because personal jurisdiction, just like venue, is waivable, that's one of the arguments I'm going to have. The argument that your authors are making that because venue is waivable, it's not jurisdiction, is nonsense, because clearly everyone agrees personal jurisdiction is part of what's necessary for jurisdiction, and it's waivable.
Like I'm saying, I'm agnostic on that. I would need to do further research. It's not relevant to this debate.
Okay, it is relevant in the sense that there's also no personal jurisdiction that Boseberg has.
But you agree the Supreme Court didn't rule on that, right?
Well, it said that there's not jurisdiction.
Yes or no?
So yes, it did.
Wait, you think they ruled on personal jurisdiction? Where's the personal jurisdiction analysis in the Supreme Court?
Well, I think what the Supreme Court ruled on was that only one court had jurisdiction, which is what they said. And then if your argument's to go to the concurrence, right? Because it has to be in the area confined, and in the concurrence it says, by the way, this is either an issue of territorial jurisdiction, which is venue, or confinement, which is personal jurisdiction. Then yes, because they mention it has to be the area of confinement, that would mean that they are saying, along with the concurrence, that it didn't have personal jurisdiction.
Wait, no, you agree that the Supreme Court holding, the per curiam decision, does not reference, doesn't do a personal jurisdiction analysis, right?
Wait, what it does is it references the Padilla case. Correct? You agree with that?
Yes or no? It references the Padilla case.
Okay.
Yes, so it references the Padilla case.
Because of it says that that habeas is the sort of remedy, right? And so because habeas is the remedy, it reflects on the Padilla case, and it says we agree with the Padilla case that the only court with jurisdiction would be the court in the area of confinement. One of the ways you get out of that is trying to say, well, wait a minute, though. When it says jurisdiction, it doesn't really mean jurisdiction as defined. What it means is territorial jurisdiction, which means venue. But you're getting that from Kennedy.
Sorry. Territorial jurisdiction, I'm not saying means venue. I say territorial jurisdiction in the context of the habeas statute refers to a geographical location. In the habeas statute, that rule is a venue rule. But territorial jurisdiction, I'm not saying is the same as venue. I'm not saying that.
Okay, well, then you're saying that the habeas territorial jurisdiction rule, and you get that from Kennedy, but Kennedy also says that there's two parts of this. In order to have jurisdiction on these habeas, it would violate either venue or personal jurisdiction because of the area of confinement.
The immediate custodian rule is about personal jurisdiction.
Correct.
Personal jurisdiction, which is different than venue. They're not the same thing. And but I'm not talking about the immediate custodian rule. We're talking about the territorial jurisdiction.
But it doesn't matter that you're not saying about the immediate custodian rule, because the Supreme Court is. The Supreme Court, yes, it does.
No, it's not. Where is it?
Let me repeat. It says jurisdiction lies only in one district, the district of confinement. Right. And so the reason is but it is right, because the district of confinement would imply the reason for that is because one, territorial jurisdiction, and second, because personal custodian.
No, it's not referencing it's not running a context analysis of the specific custodian. It's not talking about whether or not he was present in the state when they served him with notice. It's not running any kind of thing, even approaching a personal jurisdiction analysis when it comes to the custodian. It's just not.
It says so your argument is when it says personal confinement, and it's talking about the immediate custodian, that then the person, in this case it was Rumsfeld, can't be charged because it has to just be the person. They don't have personal jurisdiction over him.
So I'm not understanding. Can you say that one more time?
So you're saying when Kennedy's talking about sort of the idea of it could be, let me pull this up. When Kennedy's talking about, let me find it. The immediate custodian.
I'm referencing, yeah.
Okay. So
yeah, let's
read what Kennedy says. All right. Here's what he says. I join the opinion of the court. The separate opinion is added to my understanding of how the statute should be interpreted in light of the court's wording. The court's analysis relies only on 2 rules. First, that habeas action must be brought against the immediate custodian. Second, when an action is brought in the district court, it must be filed in the district whose territorial jurisdiction includes the place where the custodian is located. Right?
Yep. 2 different things.
Okay. So the argument is then, and I'm just trying to clarify, I'm not a gotcha, that the first part is why Rumsfeld himself couldn't be targeted.
So it's not clear to me, and I don't know if it's relevant here. There's basically a line of doctrine about who the immediate custodian is, like if you know them, and I'm not familiar with it, so I don't know.
Let's continue. So it says that it must be filed in the district court where territorial jurisdiction includes the place where the custodian is located, right? So, I mean, already based on your definition of jurisdiction, that's game over. That's the only place that it is, right? The
That's
only
referring
place,
to a physical location again.
It doesn't matter if it's
physical land.
Can any other court adjudicate or issue a decree?
Yes, if it's waived.
But it's not.
If it's not waived, then venue is proper only in one place.
Can personal jurisdiction be waived?
Yes.
Okay, therefore personal jurisdiction is not jurisdiction.
No, I told you already that I'm agnostic on that. I need to do additional research on that.
Show me one Supreme Court decision or any other court decision that says personal jurisdiction isn't jurisdiction because it could be waived.
I told you I'm agnostic on that. Did you hear me?
Okay, so in other words, the waivability is not sufficient to prove a lack of jurisdiction.
No, it's some evidence that it's not jurisdictional, and which is what the
Can you
treaties
provide
writers
me any?
found.
Can you provide me any evidence on personal jurisdiction that that's the case? Any?
I just told you. Wait. I just told you the evidence I can provide you is that personal jurisdiction is not the same as venue. But I don't. I told you I'm agnostic on whether or not lack of personal jurisdiction means that the court has no jurisdiction. I'm agnostic on that. I need to do additional research.
The authors that you're citing basically say this. They say like, well, because venue could be waived. For example, if I could waive, I don't know, I'm in the Southern District of Texas, and I think it should be and I get filed in Northern District. I can say, I waive venue. It doesn't matter. Then that proves that it's not jurisdictional, right? But is there any other argument that your authors provide as to why venue isn't jurisdictional?
So because by definition it's not.
How so?
It's an analytic fact. It's a fact that's true by definition and based on what human beings have designated terms to be. That venue is different than jurisdiction, and so it's just definitionally true. Okay,
but define jurisdiction.
We already did that.
Right. So define it again.
A court's power to decide a case or issue or decree.
Okay, so any court that doesn't have the power to decide an issue or issue a decree doesn't have jurisdiction.
A court that lacks the power to decide a case or issue a decree lacks jurisdiction.
Okay. If I could waive my personal jurisdiction, but I choose not to, right? And a court is found to not have personal jurisdiction over me, despite the fact I could waive it, do they have jurisdiction over me?
Yeah, I told you I'm agnostic on that.
But can you provide?
To see how the courts interpret that.
But
I didn't come prepared to discuss that distinction.
Okay, but you're incapable of providing any evidence of any sort of case law that suggests. Well,
no, I think that what you're saying, I'm just being good faith now, and I'm giving you my. I don't think it's relevant, but I'm just going to give you my take. I think what you're suggesting is intuitive to me, like, and that argument kind of follows. But there's other differences between venue and personal jurisdiction, where personal jurisdiction is specifically about the parties, and venue is about the geographical territory. And so, I think there's an additional delineation between venue and personal jurisdiction that would say that it's possible, conceivably, that it's both the waivability and the fact that it refers to not parties but geographical space that characterizes one as venue versus jurisdiction. But I told you I'm not prepared to discuss that, and I'm agnostic on it.
But you're circular in your logic, because the logic is this: we gave the definition of jurisdiction, and that is. Courts, let me make sure I get it specifically so no one accuses me of it is court's power to decide a case or issue a decree.
Yep.
If only one court has the power to decide a case or issue a decree, then all other courts lack jurisdiction, correct?
Correct.
Okay. So which courts had the power to hear the Padilla case or the Boseberg case?
All the district courts in the United States.
They did not.
They did, according to what the courts have interpreted power to mean.
Show me an example.
So I'll give you an example. The case, this is the Fifth Circuit case. It is Driscoll versus New Orleans Steamboat Company. Footnote 1, venue is distinct from jurisdiction. Venue may be proper or improper, independent of questions of subject matter or personal jurisdiction. Proper venue is distinct from the notion of a forum convenience is something separate. But yeah, so it is the case that you can lack jurisdiction or have jurisdiction, but venue is improper. And
that doesn't
another case that I provided.
But that didn't say anything about the word power.
So yeah, so here's so you want the definition, or sorry, the actual case to use the word power, right? Is that what you want?
I want you to show me an example. If there's only one court that has the power to decide a case, right? And you're saying that everyone's admitting there's only one court that could do this, right? Only one.
Wait, can do this. I don't take to mean the same thing as power.
Okay. What do you mean power by then?
Power means some kind of inherent authority that is further defined and grounds out into the case law.
Okay, so in order for the court to have power to decide a case or issue a decree, what would it need?
It would need to have authority to issue the decision, but a specific set of authority delineated and categorized by case law, as further elaborated in case law.
So if in a specific case only one court had the authority and the rest of the courts didn't have the authority, then they wouldn't have jurisdiction.
It depends on whether authority refers to the courts, the further definition of power as understood by the courts. So you're not going to get away from this, Rob, right?
No,
so
because it gets to the point of territorial jurisdiction, right? Because when you're incorrect in what you're asserting that territorial jurisdiction is. Territorial jurisdiction can include venue. So, for example, a case that has an improper territorial jurisdiction will always have an improper venue. But cases that have improper venue don't always have improper territorial jurisdiction.
No, wait, that's not true.
It is true.
That's not true.
Go ahead. Explain why not.
Yeah. So it could be the case. So if what you mean to say is territorial jurisdiction, what do you mean by territorial jurisdiction in that context?
I mean the area for which a court has authority over, the physical area.
Yeah. So geographical area is not equal to venue. So a venue is defined by a geographical area, but they're not coextensive meanings. So
right,
I don't take territorial jurisdiction to mean venue. And so, but even broader than that, it's possible, right, to have it's possible to have proper venue, but no jurisdiction.
That's true, because you could have other types of.
If that's true, that it's proper to have venue and not jurisdiction, and it's proper to have jurisdiction and not venue, that means it's possible that there be only one court that has the that can actually rule in a case in terms of actually giving a rule of decision, and every other court could notwithstanding that fact have that power, just have improper venue, and that wouldn't mean that
that would mean that they don't have jurisdiction.
Wait, but it's
jurisdiction by definition. Jurisdiction by definition is a court's power to decide the case or issue a decree. If they do not have that power, then they do not have jurisdiction.
So if there are two courts where venue is proper and they have jurisdiction, so for example, suppose the habeas statute said it's in the place of confinement or in the District of Columbia, right? So it's two, right? It's you can default out to District of Columbia if you wanted. Would you agree that if they brought it in New York, and they dismissed it for improper venue, would it also be jurisdictional?
If it had the jurisdictional power, but they said the reason they were dismissing it for venue was it was more convenient to do it in the other venue, then no, they still had jurisdiction. No, right, but it doesn't just. Yes, venue means it's not just a matter of convenience. Venue means that it's the improper form, the improper court. Correct?
Right.
So that's why you could have, for example, let's say that a person. We would agree that federal criminal courts in the United States have the ability to try murder, right?
Certain types of murder.
Okay, so let's assume one of those types of murder that they're allowed to try. Let's say that there's an individual that they would have personal jurisdiction over. He lives in the state of New York, right? So they have personal jurisdiction over him. He goes to Spain. He murders someone in Spain. Does federal courts have the territorial jurisdiction to try him for murder?
Almost certainly, yes.
They would. To try for a murder that occurred in another country.
Yeah. So there's the murder statute in the United States. There are some limits to extraterritoriality that the U.S. imposes on itself, but I should say I'm not 100% sure, but it applies to like international waters at a bare minimum. And if there's sufficient like nexus with a U.S. citizen, or for example, if you murdered a U.S. citizen abroad in Spain, I'm pretty sure there are statutes that can get you for that.
I think that there are geographic areas that outside the scope of that areas that your jurisdiction is lost. For example, let's start easy with a state court, right? The state of North Carolina has the ability to charge criminal murder charges in the state of North Carolina, correct?
Yeah.
Okay, but if a murder occurs in Oklahoma, do they have the jurisdiction to try it?
Depends.
Depends on what?
Depends, quote, where the crime was committed. I can imagine a case in which, like, let's say there's a dead man switch in Oklahoma or whatever, the North Carolina, and they press the dead man switch in Oklahoma, and it causes the guy's head to explode in North Carolina. I can imagine there being so some nexus there sufficient.
The murder occurred in North Carolina. We're gonna get rid of
where did the murder occur? Right.
We're going to get rid of
where the person died.
We're gonna get rid of these insane hypotheticals, and because like again, I don't know why you have to make everything as difficult as possible like this. We'll say that a person.
I'm being good faith as fuck.
Lives in North Carolina. They travel to Oklahoma. They go to a bar. They get in a bar fight. They stab a person and kill him in the bar fight. They didn't have a bomb that they waited to press the switch until they were back in North Carolina, or waited for this person to be in North Carolina. All of this geographically took place in Oklahoma, despite the fact that this person is a citizen of North Carolina. Does the state government of North Carolina have the ability? Do they have the jurisdiction to try that case?
I don't know. I assume they don't.
Okay. So then territorial jurisdiction would mean that that's what that would be. They don't have the territorial jurisdiction.
Yeah, so I take territorial jurisdiction to get to like the inherent sovereignty of like the government there and what they can do, right? So like it could be the case that that's like an issue of both the due process clause and the federalism, that there's it's kind of a unique situation with the United States in that we split the atom of sovereignty, but it's getting at something different than venue, right? So with territorial jurisdiction used in that context, that's kind of like version one. Remember the territorial jurisdiction definitions I provided? That's like definition number one, where it's not waivable, right? North Carolina can't waive in that, Oklahoma can't waive territorial jurisdiction. North Carolina just does not have the authority to impose that restriction on
the people could waive it.
No, I don't think they could. Yeah. Well, why could they? Like,
okay, so then
I don't think they could.
Why couldn't they? Why couldn't the defendant waive it?
Because it goes to the inherent power of the court to even, regulate the affairs of what goes on in Oklahoma. So even if Oklahoma wants to have North Carolina regulate what's going on in its borders, it couldn't do so if it tried. It would have to. Maybe it could take advice from North Carolina, but North Carolina can't exercise that level of jurisdiction over situations that, again, this is me off the cuff in terms of my general understanding of territorial jurisdiction, but my understanding is it goes to the inherent sovereignty of the court, and it's not like Oklahoma can waive that and allow North Carolina to adjudicate those matters, and it's different than venue.
It's it's clear that there's territorial jurisdiction outside the scope of that. The courts don't have the jurisdiction. That would be the exact same case in this with habeas. There's no reason that the habeas all of a sudden means that the territorial jurisdiction doesn't mean they only have jurisdiction in the geographical location.
Could Congress, if it wanted to, pass a statute that says all habeas petitions must be brought in D.C.?
Theoretically.
Yeah. So it doesn't have to do with the inherent power of the states in those instances. We're just talking about the federal government here.
But again, Oklahoma could theoretically pass a law that says all of our murder trials could be charged in North Carolina if defendants waive. Couldn't they do that?
That's venue, right? That is an issue of
But
venue.
could they do that? Yes or no?
What you're describing. So could they say that trial, with the consent of North Carolina, trials occur in North Carolina? I suppose they could, Oklahoma. But then that's Oklahoma. It's kind of Oklahoma doing that and agreeing to it. But it's not like they wouldn't have the power to do that independently. They would probably need the agreement of Oklahoma. But here, what we're talking about, like Congress, if it wanted to, could get rid of all the district courts except for one. Just have one big district court that sits in the middle of Montana, and then every habeas petition is brought in Montana. So the lower federal courts are just a question of statute.
So when it comes to these district courts, right? Let's step aside with habeas territorial jurisdiction and just territorial jurisdiction that's outside the scope of habeas. All of them have geographical territorial jurisdiction areas, right?
As defined by Congress in the statutes. They have they have different like areas where they're meant to sit, and where cases that are relate to those areas that occur in the district. But those are more, again, those are venue rules. They're not jurisdictional rules.
No, it is not just. So then you're acknowledging that there's no difference between territorial jurisdiction of a district court and habeas territorial jurisdiction. All of them are venue.
No. So the territorial jurisdiction in the habeas statute is a reference to geographic area, and it is a definition that is sort of referred to for purposes of describing the correct venue. The venue statutes, as enacted by Congress, the general venue statutes, those are also venue statutes. The territorial jurisdiction argument, I assume, would apply to cases that arise in diversity, where where you're applying state law, and in federal court, and there I could see some kind of territorial jurisdiction argument. I'm not sure. I'm agnostic. I don't think it's relevant to the argument. I don't think it's relevant to what we're talking about. It is
definitely relevant, because again, what you're saying, again, you never get to the point in any of it. Now you've extended it beyond just with habeas, right? Somehow all of these courts, all of these Congress are using the term jurisdiction, and they don't mean it. Instead of saying territorial venue, they're saying territorial jurisdiction.
So again, I provided you a definition from Black Law's Dictionary that says territorial jurisdiction does not necessarily mean jurisdiction. You agreed to that.
Yes, but when it's
also not relevant.
Again, but what we said was that just because that when it's talking about territorial jurisdiction is in the ability to adjudicate within that, it's not talking about landmass. It's talking about the court's authority. So that definition of jurisdiction,
I totally disagree.
Why would that be?
What do you mean? Why would that be? It's what it is, right?
Why,
so the courts have interpreted it to be a venue provision, and so that's what it is, because that's what the courts say so.
That I completely disagree. Completely.
But the courts
never say that. The courts never say that it's non-jurisdictional.
So Trump versus JGG. For core habeas petitions, jurisdiction lies in only one district, the District of Confinement, citing Rumsfeld versus Padilla. The detainees are confined in Texas, so venue is improper in the District of Columbia.
Right. So if the territorial, so let's go back to that situation, right, with Oklahoma. The murder occurs in Oklahoma. We acknowledge that would be territorial jurisdiction, right? That's different than venue.
Potentially, yeah.
Okay.
It's hard. This is not on.
Would it also be improper venue?
They'd be independent, right? So you could provide venue. The states could, I guess, provide theoretically venue, but it would still lack subject matter. They would lack territorial jurisdiction, as I understand it. I'm not.
Just to clarify, so we're on the same page. It could be that they don't have jurisdiction. North Carolina does not have jurisdiction, territorial, to hear a murder case that occurred solely in Oklahoma.
But venue is proper.
But no,
it's not the case that venue is proper.
So if they held the trial in North Carolina, you would say, one, they don't have the territorial jurisdiction to do that, but it's also the improper venue. It would also run afoul of all venue.
It could be proper venue, right? So Oklahoma and North Carolina could both agree that the proper venue to bring a murder case that happens in Oklahoma. But
they didn't.
I'm just saying, so they're different concepts, right? So it could be the case that both states consent that venue is appropriate in North Carolina for any murder involving a citizen of North Carolina. They could both agree to it. They could both define their murder statutes and add venue statutes that say venue is proper in North Carolina for murders that involve North Carolina principles. And notwithstanding that fact, the North Carolina doesn't have territorial jurisdiction to hear the murder that occurred in Oklahoma. They're different concepts.
It's different concept, but if they didn't have territorial jurisdiction, then it wouldn't be a proper venue, even if they said it was a proper venue.
No, that doesn't follow. That does not follow.
It does.
It's possible to have venue. Why? Wait, cite the principle that where it says it's impossible to have proper venue and also have territorial.
Would you would you agree that subject matter? Would you admit that subject matter?
Wait! You're not answering my question.
What? Principle. I am. Would you admit that subject matter jurisdiction is non?
That's a question. That's a question. Wait, that's a question. That's a question. That's not an answer to my question.
Would you admit that subject matter jurisdiction is non-waivable?
So you're not going to answer my question?
I am answering your question. If a place says
a question is not an answer to a question.
If a place says, well, we're going to waive subject matter jurisdiction. Oklahoma law says subject matter jurisdiction no matters. We're going to say that all of these cases can be heard in North Carolina. It would still be the improper venue, even though they wrote a law saying it was the venue, because it lacks the jurisdiction. So just because they say that this would be a proper venue,
so this is you conflating jurisdiction.
It is only a proper venue.
This is you conflating jurisdiction venue.
No.
Whoa.
It is only a
so
proper.
You just said, whoa. You just said it's only a proper venue if there's jurisdiction. That's what you just said, right?
It can only be a proper venue if there's jurisdiction.
Okay, but I have case law that says venue is distinct from jurisdiction. Venue may be proper, improper, independent.
That's right. So all cases where there is not territorial jurisdiction would be improper venue. But not all cases where there's improper venue would be improper territorial jurisdiction. So if you lose, it does not matter if you decree. It does not matter if the government of Oklahoma decrees. We think that the venue's okay in North Carolina if they don't deal with the fact that they don't have the territorial jurisdiction. They can't just.
So why are you using the term territorial jurisdiction here? So I thought we were just talking about jurisdiction.
Because. Right, territorial jurisdiction is what Kennedy's talking about and what we specifically see in this case, right? So there's
but
different
that's not part of the argument. So the argument isn't about territorial jurisdiction. So it's not. So my argument doesn't use the term territorial jurisdiction independent of the words habeas territorial jurisdiction rule. So I don't understand why you keep going back to territorial jurisdiction. We're just examining the term jurisdiction and venue and habeas.
Again, saying the term that's fine. Right? We've already did that debate. You can't win that debate. Jurisdiction is the court's ability to adjudicate, right?
Power.
Okay, their power to adjudicate. Okay, only one court has that power. Boseberg's not
you're
that
using
court.
Power. You're using power in a way that the courts don't use it, right? So the courts will.
The only explanation you've given as to why not is to say, well, because these Kennedy and these other cases say that territorial jurisdiction equals venue. And so therefore,
I'm not talking about territorial jurisdiction. My argument does not depend on the term territorial jurisdiction. I don't know why we can't.
Let's reset then.
Okay.
Only one case in both the Padilla case and in the Boseberg case, only one court had the power to adjudicate this.
No.
Okay. They say it's only one court. They're quite expressive. That it can only happen in one
There's
court.
only one court that could rule on it because
jurisdiction lies only in one district, the district of confinement. That means jurisdiction does not lie in any other districts.
That's a reference to territorial jurisdiction. These are just.
But you keep saying I'm not talking about. You keep saying we're not talking about territorial jurisdiction.
No, but I'm telling you, there's an equivocation there, right? I'm telling you, there's an equivocation. You know what I mean by equivocation? When you're referencing jurisdiction as used in Padilla, that's not the term. That's not jurisdiction as defined as that we started when we agreed, right? The jurisdiction that we agreed at the start is the power to issue a ruling or decree. That's not what they're meaning when they're using that term in reference to the habeas statute.
Okay, so in the habeas statute, they're saying that it's only one venue that this could theoretically have.
In the Padilla case specifically, and in the JGG case specifically, there is only one venue to bring the case. Correct.
Okay, so that would mean all other venues don't have jurisdiction.
No, all other venues are improper.
Does any other venue have the power to hear the case?
Yes, every other district court.
Then why can't they?
Because venue would be improper.
Okay, but so just to be clear here, What then? Give me your definition of the word power.
So I understand power to be a term of art elaborated in case law, which is why I cite case law that distinguishes, issues that relate to the court's power, their inherent authority to hear a case, as opposed to things that are not related to the power. So that grounds out, as I said now, I think 3 or 4 times in the case law.
I'm going to
wait a second. Wait. What's wrong? What's wrong with that answer? Is there anything wrong with that answer?
Yes, that you haven't provided one case law to show that.
Wait. So
everyone who's
when I
watching
say
this, so what's Black Law's dictionary give as a definition for power?
I don't know. I didn't look up that term power, but
you got Black's Law in front of you? Look
why? Wait, why? I'm just telling you what I mean by that term.
You haven't given, like, what you've done is you've cited a bunch of, so your argument is this: yes, there's only one court that has the ability to hear this, and so if another court issues a decree, tries to adjudicate it, they can't, but they have the power to, even though they can't. But they have the power. That's your argument. And I'm like, can you make that make sense?
And you're like, courts understand power. As the courts,
you're like,
as the courts understand power.
And you're like, yeah, as the court understands power, that's what the case law says. And I'm like, can you provide it? And you've yet to provide anything.
I have. So
show me anything.
This is Nebus. So this is Supreme Court. The jurisdiction of the federal courts, their power to adjudicate, is a grant of authority to them by Congress, and thus beyond the scope of litigants to confer. This is the Supreme Court majority. But the locality of a lawsuit, the place where judicial authority may be exercised, though defined by legislation, relates to the convenience of litigants, and as such is subject to their disposition. The basic difference between the court's power and the litigant's convenience is historic in the federal courts. And it distinguishes between a defendant's personal privilege respecting the venue or place of suit which he may assert or may waive at his election. So that's the Supreme Court of the United States saying.
Can you link that anywhere? So
that's P1 supported continued. That's the tweet underneath support for P1 and P1 support continued. It's Frankfurter.
Okay. P1 support continued. Right here.
Yep.
This jurisdiction of federal courts, their power to adjudicate, is a grant of authority to them by Congress, and thus beyond the scope of litigants to confer. In other words, Congress says which courts are allowed to hear. Isn't it true that Congress put territorial districts on the district court?
Are you asking me a question?
Yes.
Isn't it true that Congress put territorial jurisdiction in the district court?
Correct.
They assigned geographies to the various federal courts.
Okay, so therefore, that would be jurisdiction.
I don't know. I'm agnostic on that.
Why?
I don't know.
It just says that it's.
I don't understand the concept of territorial
jurisdiction.
I don't understand the concept of territorial jurisdiction in the federal courts. It's except to the extent that the United States overall territorial jurisdiction, because they're federal courts, except to the extent that they're wait, let me finish my answer. Except to the extent that they're mapping on state law principles when cases arise in diversity jurisdiction and they're applying state law. I don't understand it beyond that, and I haven't done research on it.
The jurisdiction of federal courts, their power to adjudicate, is a grant of authority to them by Congress, and thus beyond the scope of litigants to confer. In other words, if there are things granted by Congress, or there are specific laws that Congress has passed that's been interpreted by the courts that says that the courts have the power to adjudicate this, then that's different than venue. The locality of the
right. So venue doesn't, whatever venue is, it doesn't deal with the power to adjudicate. That's what the court is saying clearly, right? Whatever venue does, and that may require you to dismiss every other case in every other court, but whatever venue is doesn't deal with the power to adjudicate. That's why I give you the answer that I'm telling you, because that's what the court says.
What now? Real quick, who wrote the U.S. legal code? The laws within. Is it Congress? Was the U.S. legal code? So if I go to 28 U.S. Code 2241.
Those are congressional enactments written by Congress.
Okay, so if the congressional enactment says that only one court can hear habeas petitions, wouldn't that mean that it falls in line with what you're saying here? With what your author's saying here? That would mean that only they have the power to interpret.
Because the courts have interpreted those statutes to be venue. No, and it's emphatically the providence and duty of the judicial department to say what the law is.
You could say that, okay. So this just said the jurisdiction of the federal courts, their power to adjudicate, is a grant of authority to them by Congress beyond the scope of litigants to confer, right? And so Congress wrote the law on habeas, writs of habeas, right?
Yeah.
Now they're being interpreted. In the interpretation, you're like, the court's interpretation is only one court's allowed to hear this. That's it.
only one court is where venue is proper, but that's not.
But again,
could be otherwise,
you
right?
keep conflating. You keep throwing in that term venue. It's irrelevant. Congress wrote the law.
Irrelevant.
The court interpreted the law that only one court
To be a
could hear
venue
it.
statute. The court interpreted that to be venue.
It doesn't matter, right? How does it not
matter?
If we're saying that jurisdiction is the power to adjudicate, and the courts say only one court has the power to adjudicate, and the court
That's not what they're
agrees,
saying.
that is what they're saying.
No, so you agree,
what
right? Then you agree that venue doesn't get to the power to adjudicate. Agreed?
I don't know.
You're not sure? But the court is saying that venue isn't.
I think
venue doesn't relate to the
my
power to adjudicate.
interpretation is that you could have improper venue and still have power to adjudicate, such as if the jurisdiction. Let me finish. So if there is if there's 7 district courts within one jurisdiction, right? You could make the argument that a venue is improper, but that venue had jurisdiction over it. But if there's only one court with jurisdiction, only one with the ability to hold it.
I don't understand what venue. What does it mean for a venue to have jurisdiction? I don't know what you mean by that.
So, for example, there are 6 district courts, we'll say hypothetically, in Texas. State law of Texas says district courts of Texas have the right to charge murder that occurs on the geographical location of Texas. Therefore, all 6 district courts would have. However,
have
they could
jurisdiction.
Argue, yeah, they would have jurisdiction, correct. But they could argue that one is the best venue and the other venues would be improper, even though they all have jurisdiction.
So they pass another law that says venue is proper in the district in which the murder occurred.
Okay.
So there's 2 laws, right? One is giving the courts let's say these are state equivalent courts. So this is just for the analogy. I think it's a good analogy, Rob, that you're bringing up, and I think it's a good example. So the Texas passed a law that says the district courts of Texas shall have the authority to adjudicate murder cases. And then they passed another law that says venue shall be proper in the district. Venue shall be proper in the territorial jurisdiction of the district court in which it occurred. That's a venue statute.
Okay.
And then so then there's only one court where venue would be proper. But every single court in Texas has the power.
In this hypothetical, if Congress passes a law that says only one venue is appropriate.
Yeah.
Yes, then because
of
that specific law, even though it's venue, we would say that is because of the law, that is the only court with the jurisdiction to adjudicate the case.
But the Supreme Court is telling you there's a difference between power to adjudicate and venue. And so if Congress passes a law that says there's only one place where venue is proper.
Where's it saying that?
Yeah, it says the jurisdiction of the federal courts, their power to adjudicate is a grant of authority to them by Congress, and that's beyond the scope of litigants to confer. But the locality of a lawsuit, the place where judicial authority may be exercised, though defined by legislation, relates to their convenience of litigants and as such is subject to their disposition. The basic difference between the court's power and the litigant's convenience is historic in the federal courts. So there is, so Congress could pass a law that relates to convenience that says only one court is the place where venue is proper. But it would still be a venue statute, and it wouldn't go to the power to adjudicate.
It would go to if they said that, because that first sentence, the jurisdiction of the courts, their power to adjudicate is a grant of authority by Congress. So if Congress specifically creates a law that says only this one court has the power to adjudicate because it's the only proper venue, it would not matter that they use the term venue.
But, there's the conflation, right? There's that conflation. So power to adjudicate is separate from venue. And you said you didn't know about that. But I want to ask you again, isn't power to adjudicate different than venue, and venue isn't about power to adjudicate by definition?
I would think that I would go back to the previous answer that I had, that you could have improper venue but have jurisdiction.
Right. So you can have, but you can also have jurisdiction and improper venue, right?
Correct. You could have subject matter jurisdiction but have an improper venue.
Whoa, why'd you say subject matter jurisdiction? Because you could have improper jurisdiction and proper venue, right?
Not territorial.
Well, I'm not talking about territory. I'm just saying you could have improper
So you could have improper personal jurisdiction, improper subject matter jurisdiction. I'm saying
we're just talking about jurisdiction.
I'm talking about you could not have the only jurisdiction that I foresee it's not being able to meet this burden would be territorial jurisdiction. So if you do not have territorial jurisdiction, then you do not have proper venue. You cannot have proper venue and improper territorial jurisdiction. Again, I'm going to go back, I'm going to go read.
Oh, God.
Oh, shit. All right, screwed the pooch there. I can't believe I just did that. Get 1 second. I want to read the
Okay,
rest
go for it.
of the Padilla concurrence.
Go for it.
All right. Join the opinion of the court. This separate opinion is, let me bring it up on the screen. It might be easier for people. That should be interpreted the court's holding. The court's analysis relies on two rules. The habeas action must be brought against the immediate custodian. Second, when an action is brought through the district court, it must be filed in the district court whose territorial jurisdiction includes the place where the custodian is located. These rules, however, are not jurisdictional in the sense of a limitation on subject matter jurisdiction. Well, why does he say that? Why does he further add when it comes to subject? Why doesn't he just say these rules are not jurisdictional?
I don't know. You're asking me a question. I don't know what was in his head, but I'm telling you what the usual definition of jurisdiction is. It relates to something inherent in the sort of power inherent to the court.
Well, we'll get to.
So I don't understand.
My point is that he, like you, is saying, well, wait a minute. We're not saying that it's not subject matter jurisdiction. That much is clear from many cases which petitions have been heard on the merits, despite their non-compliance with either one or both of the rules. Right. So other cases have been heard.
Right. So notice what he's saying there. So what he's saying there, and this is really good, and I'm glad you pointed it out, is that they've ruled on habeas cases where venue was improper because it wasn't raised. So it's clear that the courts in which that has happened, they had the power to adjudicate. No one raised venue, and so they heard it on the merits.
But they have subject matter jurisdictions. What he's saying, right? So if you waive the territorial jurisdiction or personal jurisdiction, sure. I don't think
I don't see if what you mean by territorial jurisdiction is one of the definitions that are provided. That's not waivable. You can't how do you waive that? How do you waive like your inherent right to control, land in some other place?
The United States. I'm going to continue on. In my view, the question of the proper location for habeas petition is best understood a question of personal jurisdiction or venue. This view is more in keeping with the opinion in Britain and its discussion exposing the rules from the proper form of habeas petitions. See US 493, indicating that the analysis guided by traditional venue considerations and traditional principles of venue, suggesting that the territorial jurisdiction rule is a venue rule and the immediate custodian rule is a personal jurisdiction rule. This approach is consistent with the reference in the statute of respective jurisdictions of the district court. As we have noted twice, this term, the word jurisdiction, is susceptible of different meanings, not all of which refer to the power of the federal court to hear a certain class of cases. The phrase respective jurisdiction does establish a territorial restriction on the proper form for habeas petitions, but does not necessarily establish the limitation that goes to the power of the court.
To the power of the court to hear the case. That's our definition of jurisdiction. Wait, that's our definition of jurisdiction.
It is not, because you'll see as we go further. Because the immediate custodian and territorial jurisdiction rules are like personal jurisdiction or venue rules, objections to the filing of petitions based on these grounds can be waived by the government. So he's saying you could waive personal jurisdiction or you could waive territorial jurisdiction.
Correct.
Okay.
Well, no. Waive venue.
Okay. Regarding the fact that no respondent was ever served with the process and the proceeding is not important. The United States issued, for the same reason, the immediate custodian and territorial rules are subject to exceptions as acknowledged in the court's opinion. This does not mean that habeas petitions are governed by venue rules and venue considerations that apply to other sort of civil lawsuits. Oh, so it's not the same as any other venue considerations in civil lawsuits.
It's not one with the general venue statute. So there he's saying, so there are venue statutes and principles in the federal rules of civil procedure that are like generalized venue principles in the civil context. What he's saying is this is like a unique set of venue case law that you can't just apply everything from the venue principles in the federal rules of civil procedure to the venue case law on habeas. That they're not, you don't assume is what he's saying, but he's not saying it's not venue. He's just saying it's not one-to-one with the other venue case law.
He's saying habeas is unique, and the way this is going is unique.
It's unique. It's unique with respect to the case law on venue in the habeas context versus the federal rules of procedure.
Although habeas actions are civil, he continues. Although habeas actions are civil cases, they are not automatically subject to all federal rules of civil procedure.
Correct.
These rules are applicable to proceedings for habeas corpus to the extent that the practice in such proceedings.
And one of the reasons for that, Rob, one of the reasons for that, and one of the reasons why this is such like an odd statute, is because the habeas statute like predates the federal rules of civil procedure. It's one of like the oldest. I'm sure there've been like edits and additions on it or whatever, but the habeas statute is like older than modern federal rules.
Instead, these forum location rules for habeas petitions are based on the habeas statutes and the cases interpreting them. Furthermore, the fact that these habeas rules are subject to exceptions does not mean that in the exceptional case, a petition may be properly filed in any of the federal court districts. Just because there's
any.
Yeah, that it may not.
That's what I said, right? For power.
No, it may not.
Yeah, but he's basically saying what I'm saying, which is like all of the any federal district court has the power, but they just venue might be improper in them, and we should listen to the venue case law specifically on habeas.
He's saying these forum location rules and habeas petitions are based on statutes. The fact that these rules are subject to exemptions, so there could be the exceptions that you're talking about. You could have waived it. That's one of the exceptions, right?
I think so, but yeah.
Okay. Just because you could do that and there could be exceptions doesn't mean that you could file that any court has the power to hear this, that you could file anywhere. That's what he's saying.
It says, furthermore, the facts that the habeas rules are subject to exceptions does not mean that in the exceptional case, a petition may be properly filed in any one of the federal district courts. It's basically saying that these are, again, it's stressing these are like unique circumstances, and just because there are unique circumstances doesn't mean that you can file in any district court you want, but all district courts have the inherent power.
Still must take into account the considerations that in the ordinary case are served by the immediate custodian rule, and in similar fashion, limit available forum to the one with the most immediate connection to the named custodian. In other words, what you must do, where you must file, even if there are exceptions, are where the immediate connection is, and in the location, the court with the geographic location, correct? That's the only proper place to hear.
That's the only place where venue is proper. Yep.
In other words, that's the only place with the power to adjudicate.
No, that's explicitly what it's not saying. It's explicitly. So why are you denying reality? It's literally distinguishing between the power to hear a case and these other considerations. It literally is saying that, and you're saying it says the opposite.
The next line, which I think is going to be devastating to you, because this is the only thing you have that talks about sort of territorial jurisdiction being only venue. It says, quote,
I have the modern
quote. I would not decide today whether these habeas rules function more like rules of personal jurisdiction or rules of venue. So he's not deciding that this is if it's personal jurisdiction or rule of venue.
Yeah, the Supreme Court did in the recent case.
It didn't.
It said venue.
It said venue, but it said venue, but it also said jurisdiction. Just because they said we're not saying personal jurisdiction.
But that's a reference to the habeas usage of the term jurisdiction. It's not to personal jurisdiction.
It is difficult to prescribe the precise nature of these restrictions on filing of habeas petitions, as examination of the court's own opinions will make this clear. The precise question of how to best characterize the statutory direction respecting where the action must be filed need not be resolved in the finality of this case. There's been no waiver by the government. There's no established exception, and the immediate custodian rule or the rule that the action must be brought in the district court with authority over the territory in question. And there's no need to consider some further exemption to protect the integrity of writ. So this would be the same in the Boseberg case. There's only one court where this could have been filed.
Where venue is proper.
So all other courts would have, would any other court have the power to adjudicate this?
Yes, every other district court.
So I just completely disagree with you. I completely disagree.
I'm just following what the courts say. The power to adjudicate is separate from venue.
The court is made. Let's see. Where were we? The court has made exceptions in the case of non-physical custody. Of dual custody, that these exceptions won't apply. We don't need to further read those. I think that
understand this. I don't know.
So to me, if no other court, if this couldn't be filed in any other court, then they don't have jurisdiction. That's
not how they use the term jurisdiction, though. That's your own private definition, proprietary language.
It is not.
Well, I'm pointing you to the language of the Supreme Court that uses that term differently.
What it's saying is, when he's saying that, what he's talking about specifically is they have subject matter jurisdiction. He specifically says it. You're incapable of explaining to me why he adds the term subject matter jurisdiction here if he just means that there's
Why
no
do I need to
jurisdiction.
explain that?
However,
Why do I need to explain that?
because if he's specifically saying that's not jurisdictional in the limitation on subject matter jurisdiction, he's not saying that it's not jurisdictional in any other type
okay,
of
but
jurisdiction.
we agreed with the definition of jurisdiction at the start from Black's Law Dictionary that has the power to adjudicate the case, and in that specific Kennedy opinion, it goes and it says that it doesn't get to the power to decide the case, and you even read that line. And so it is whether or not it's delineating subject matter jurisdiction, because like I said, that's the default understanding of what jurisdiction is, and that's what people use the term jurisdiction independent of other terms to mean. That basically, even though they specify subject matter jurisdiction, doesn't mean they're not also referring to general jurisdiction, and not general jurisdiction as understood as a specific term, but the general term jurisdiction. And the proof of that is there's a whole sentence that uses the definition from Black's Law Dictionary that says the power to adjudicate. So I just don't know. It seems like you want to introduce a proprietary definition of jurisdiction that doesn't match what the Supreme Court is saying.
But the power is conferred by Congress. That's what your other source says, sir.
Yeah, I think there's that's what the other case says in general, because that's
And you would admit that the habeas case is unique.
In what sense? In what respect, Charlie? I don't know what you mean. Yes, I guess.
Right. So when it's talking about things like respective jurisdictions, etc., even Kennedy's admitting that's not the same as when we're talking about these sorts of terms in other cases.
Yes, it's not referring to the power to adjudicate. It's not referring to power to adjudicate. It's referring to geographical space.
Let's see. I have some stuff written down here. Not the concurrence, but the... One second. The regular hearing or decision, not the concurrence. Last paragraph before section 3. This rule, derived from the terms of the habeas statute, serves an important purpose in preventing forum shopping by habeas petitioners. Without it, a prisoner could name a high-level supervisory official's respondent and then sue the person wherever he's amenable to long-arm jurisdiction. The result would be rampant forum shopping, district courts with overlapping jurisdiction, and the very inconvenience, expensive embarrassment of Congress that sought to avoid it when it added jurisdictional limitations 137 years ago. So this is directly speaking to what happened with Boseberg. With Boseberg. With the idea of forum shopping, that the reason that they're only allowing this, so you'll admit that this was forum shopping?
No.
Well, that's what they're.
Well, I mean, in a sense, yes. I mean, these litigants are forum shopping, yes.
And
but so do conservatives.
This is a disaster when it comes specifically to habeas.
Well, that's not part of the argument, but so I agree, by the way, and so does Boseberg. Boseberg agrees with the territorial jurisdictional rule of habeas. His whole argument and the argument from the plaintiffs was we don't have to bring a habeas case. So that's what also, by the way, why your argument that it's blatantly obvious that this is ridiculous or that he didn't have jurisdiction, Boseberg was acknowledging the reason why they amended out the habeas claims is because Boseberg signaled that he was going to dismiss them for lack of venue. And so that's why the litigants got them out, is because Boseberg acknowledges the venue rule, but they had this other theory under the Administrative Procedures Act, which wasn't blatantly obvious. I'll let you know, it split the district court 2-1 in favor of the plaintiffs, and it split the Supreme Court 5-4 in favor of Trump. But yeah, so it is the case that the litigants were forum shopping to go to DC. 100%. I agree.
I still don't understand why they would use the term. Excuse me here. Why would they use the term territorial jurisdiction as opposed to territorial venue?
Because they're using territorial jurisdiction to refer to geographical space, and that is deriving the venue, right? So they're using territorial jurisdiction, it's respective jurisdiction, but it's understood by the courts as territorial jurisdiction as a reference to geography, and that geography defines the venue.
Going back to the concurrence real quick, I wanted to read language real quick here again. Does the court having the power to hear the case necessitate that it has the power to adjudicate the case?
Power to hear the case, power to adjudicate. I take those as synonymous unless I have a reason to think otherwise.
So if
I
if a
don't
court-
see a distinction there.
okay, so anytime a court has the power to hear the case, they would also have the power to adjudicate it or issue a decree.
I would treat those as synonymous unless there's I'm no reason to treat those as different. Adjudicate here.
Did Boseberg have the power to issue this TRO?
He had the power to issue the TRO, in the sense that power refers to jurisdiction as understood by the case law. He had the power, but it was improper venue, and therefore the TRO was invalid.
So, because hypothetically, if it was the proper venue, he would have the ability to write this. He has the power to do it.
The venue doesn't relate to the power. They're distinct concepts.
Well, I understand. I understand that they're distinct, right? But if it was, you're saying he has the power because if he had proper venue and he issued this decree, it would have went through.
I say he has power because he has the authority to adjudicate the claim, but as understood by the case law. I think the waivability is like one. It's some evidence, but I'm agnostic that just because it's waivable, it doesn't relate to jurisdiction in the main. That's my inclination, by the way. My inclination is that personal jurisdiction isn't a subset of the court's jurisdiction, but specifically, it's jurisdiction over particular parties. So my main inclination is that subject matter jurisdiction is the best way to understand jurisdiction, but I think that the term jurisdiction is broader than just subject matter jurisdiction, because I do think it includes one version of territorial jurisdiction, the non-waivable kind of territorial jurisdiction. But again, I don't think it's relevant to the argument. But I think the waivability
I think the waivability is a weak argument because I just don't think that you're going to find any evidence to suggest what you're agnostic on there, that personal jurisdiction may not be a form. Because if that's the case, right, like then the only forms of jurisdiction would be what? Subject matter?
This is just this is not, I don't have a strong degree of confidence that I need to do the research, but it would be non-waivable territorial jurisdiction and subject matter jurisdiction, which is inherently non-waivable.
Okay, so what's non-waivable territorial jurisdiction?
So territorial jurisdiction, not in the sense of geography, but in the sense of the kind of sovereignty of the government behind the court.
The sovereignty of the government.
So definition one of territorial jurisdiction over cases arising in or involving persons residing within a defined territory. But again, that's just kind of grounds down into jurisdiction, which again grounds out into power to adjudicate a little bit. So right, because definition one of territorial jurisdiction is a type of jurisdiction. Just to be clear. So it might all just ground out into subject matter jurisdiction, but I'm just telling you what the definition of jurisdiction as understood by the courts is, which is power to adjudicate the case. And I would take definition one of territorial jurisdiction to be a subset of jurisdiction.
I disagree. Now, would you say with not the concurrence, but with the three judges on the top, right?
Mm-hmm.
Do they think, in your reading of it, I read it as well, they don't make any sort of claims that this jurisdiction is just venue, correct?
So they don't specify that specifically. They don't decide that, I don't think. The footnote 7 is them saying, hey, we're talking about jurisdiction here, but they're not worried about construing it as a venue or personal jurisdiction that matter. But what we do know is the Supreme Court now has construed it as a venue situation, because that's what they said. But I do think, by the way, that that's what the court meant in Rebsil versus Padilla, because I think that Kennedy's concurrence is instructive, and it should be given weight because it was, the deciding votes.
I just don't think that the only line you have to suggest this is Kennedy saying, let's see. It doesn't out of necessity establish the limitation that goes to the power of the court to hear the case.
Mm-hmm.
That's the phrase respective jurisdictions. Mm-hmm. Right?
So if it doesn't go to the power to hear the case, it doesn't go to jurisdiction. Because that's our definition of jurisdiction.
So I don't think that does enough to prove that they have jurisdiction. I just don't.
Okay.
Let's see where it says
based on what, if you don't mind me asking.
Yeah, I think that based on the definition of the power to hear, or the power to adjudicate and issue decrees. I think that the fact that only one court is allowed to do that the other courts don't have the power.
But then you're saying that venue is coextensive with jurisdiction, but that's clearly not true.
But other cases, in these situations that I've given, other cases, courts would have that power, but through convenience could be asked not to and given it to a different court. For example, if all the courts in Texas have jurisdiction, but the court rules that the Northern District is improper because closer, they would have jurisdiction.
But they wouldn't have venue, and there's only one place to hear the case, which is, let's say, in the Southern District.
But it wouldn't be the only place. Other places would have jurisdiction.
But they wouldn't have venue, and so you can only really bring the case in one place.
But again, they would still have jurisdiction.
Just like in here, Boseberg has jurisdiction. He just doesn't have venue. Same thing.
Does not, right? Because it doesn't say, there is nowhere written in the law that says that he would ever be able to hear this.
It does. It's waivable, right? So he could hear it.
But again, it gets back to, but just because a type of jurisdiction is waivable, if it wasn't waived,
venue is not a type of jurisdiction.
What's that?
I guess that's begging the question, but because I'm saying it is venue, because that's my conclusion is the courts say it's venue, and therefore we should take it as venue, and venue is not jurisdictional. That's basically it.
But the only reason
I don't understand how you contest that.
But it doesn't say that it's just venue. It also says that it doesn't have jurisdiction.
I know, but that's an equivocation, and I'm explaining to you when they use jurisdiction in the habeas statute, it's a reference to territorial jurisdiction, referring to geography. I keep trying to repeat that, and we keep going in circles.
But again, even if it's a reference to territorial jurisdiction regarding geography, it's saying that there's only one jurisdiction or only one court with that territorial jurisdiction.
Yeah, which is where venue is proper.
Right. But that's different than other places if there's multiple courts where there's territorial jurisdiction.
So there could be multiple courts where venue is proper, or there could only be one where venue is proper, which has territorial jurisdiction in the sense of geography.
Again, the point that I'm trying to make is if you have that state where there's multiple districts and each district has the power to hear this because it specifically says any court within this could hear, but there are matters of convenience, which as the Niebuhr
But that's how the court has interpreted, right? So the court has told us not to interpret it in the manner of subject matter jurisdiction. They've told, or any other kind of the power to adjudicate the case. They've told us to interpret it as venue. That's what they've told us to interpret it as. And so I take that to be the definitive rule on whether or not it is of the venue type situation or if it's of the jurisdiction type situation.
Well, I think
the court tells us,
even if it is venue, even if they say that we're going to interpret it and say it's an improper venue, that doesn't necessitate just because it's improper venue that it doesn't have improper jurisdiction in other senses. It could additionally have improper territorial jurisdiction.
It could have other things that divested of where Boseberg didn't have jurisdiction. But what other things that did the Supreme Court rule on that divested him of jurisdiction?
Well, it's territorial jurisdiction.
They didn't rule on that. They didn't say that DC lacked territorial jurisdiction. They said it lacked venue.
If you ignore that the word jurisdiction means jurisdiction.
But we've already gone over that. It's an equivocation in the habeas statute.
But you're saying it's an equivocation. I just don't believe that it means. I believe.
Okay.
I believe that, and even in a technical stance, right, it would still be appropriate to say that they lack jurisdiction. Correct.
If you mean a proprietary definition of jurisdiction, which doesn't mean the power to adjudicate a case, then you would be right by definition. If what you mean by jurisdiction is whatever you meant by jurisdiction, which I don't know, is the what are you saying?
Well, the Supreme Court's saying that they lack jurisdiction. Boseberg does.
No, they say that he lacks venue.
Well, he is in a court that doesn't have jurisdiction.
Territorial jurisdiction, defining the venue. So the territorial jurisdiction of Boseberg shows that it's an improper venue because the venue is only proper in a place of confinement wherein it's sort of encompassed by the territorial jurisdiction, which means geography.
Right. So there's only one territorial area where they could have this. right?
Or venue is
The
proper.
area of the area of confinement. Therefore, it would be improper territorial jurisdiction in any other venue.
No, I don't know what it means to be improper geography. If what you mean by improper geography, I'm using territorial jurisdiction here to mean definition number 2 to mean geography. I don't know what it means to be improper geography. It's improper venue.
It's the territorial jurisdiction. You're saying it doesn't mean the district that they're allowed to adjudicate under.
It's a reference to geographical space that defines where venue is proper.
Okay. That in your definition of territorial jurisdiction, let's see specifically what it says.
Sub 2.
Territory over which a government, one of its courts or subdivisions has jurisdiction. So the landmass of which they have jurisdiction.
Over which, one of its courts has jurisdiction.
Okay. And we're saying, so that's what you're saying they mean when they say territorial jurisdiction with habeas.
Yeah.
So the landmass itself. So in the area where they're saying the specific confinement, the district there. So in this case, it's Texas, that district court there that would, we'll just assume it's the whole state of Texas.
Yeah, Southern District of Texas.
Okay,
whatever,
Southern District of Texas. So that's the only place with territorial jurisdiction to hear the case.
That's the only place with proper venue because it has territorial jurisdiction. Its territorial jurisdiction includes the place where the confinement is happening.
Is there any other place with territorial jurisdiction to hear this?
There's no other place with proper venue, which is defined by the scope of the territorial jurisdiction. The only proper venue, by definition, right? There's no coextensive. The districts are not overlapping. So the District Court of Texas, wherever that is, right, is the only one that has a territorial jurisdiction, which encompasses the place of confinement because we don't overlap the districts.
Okay, so if that would mean you could say territorial jurisdiction equals venue, right? But this would mean that no
I'm
other.
not saying that.
Okay. Okay, so I'm not understanding what you're saying on this specific point. Can you restate that specific point? Because we see there's only one district with territorial jurisdiction.
There's only one district whose territorial jurisdiction includes the place of confinement. That's the way to say it.
There's only one territorial jurisdiction.
There's only one district court whose territorial jurisdiction includes the place of confinement.
Okay, so you're saying then that all these other areas that have territorial jurisdiction in their specific areas, like the area that they have, that the reason they can't hear this case isn't because the territorial jurisdiction is limited to the area of confinement. It's because the venue is limited to the area of confinement.
I didn't understand the question. Can you repeat it one?
So you're saying that the territorial jurisdiction, right, is the reason that these other places outside of this territorial jurisdiction can't hear the case is because of improper venue, not because of territorial jurisdiction.
Not because of territorial jurisdiction. That's right. In the sense that territorial jurisdiction defines the scope of venue. And so venue is not coextensive with territorial jurisdiction. They're related concepts, right? Because venue, in this case, is defined by territorial jurisdiction. So they're related, but they're not the same thing. And so the other courts can't hear it because their territorial jurisdiction does not include the place of confinement. And therefore, venue is improper.
Let's see here. I think that it's easy to understand that if every other, to me, the term territorial jurisdiction here implies that any other place would be unable to hear it. They don't have the geographic, because they're not in the geographic area, they can't hear it. So, for example, if I'm
the person, can't hear it because of venue, yeah.
Right. If I'm the person, for example, Donald Trump was named as the defendant, right? And you need to have territorial jurisdiction in order to. You have to have personal jurisdiction over me. You have to have subject matter jurisdiction. You have to have territorial jurisdiction. There's other things like, I forget what, like the specific type of relief, you have to have jurisdiction to offer that, right? If you lack any one of those, then you don't have jurisdiction, correct?
No, I think that jurisdiction means the power to adjudicate the case, and that's what we seem to agree on at the beginning. And so, no part of that definition, I think, says what you say.
Okay, so do you have the power to adjudicate the case if you don't have personal jurisdiction?
I told you I'm agnostic about that.
But I think that to me, that's a complete and utter failure on your part.
Why?
Because there's no one that I'm aware of in the legal field that would agree with you. Can you show anyone?
The Supreme Court of the United States.
Okay, can you, in what sense?
Which says that the power to adjudicate doesn't include venue.
But we just talked about personal jurisdiction, and now you're moving on to venue.
Yeah, so I told you I haven't done the research on whether or not jurisdiction in terms of the power to adjudicate includes personal jurisdiction. I told you I'm agnostic. And you
right,
said
but my point is
right.
But my point is, like, I feel that you need all of these things in order to be able to adjudicate.
No, logically you don't. If you just know what it excludes, right? I don't need to understand jurisdiction in all its capacities to know that it doesn't include venue.
Wait, say it. But you have to understand that there's more than just subject matter jurisdiction that's necessary in order for a court to have jurisdiction.
Why would I need to know that?
Because
there's a definition of jurisdiction, and
we have to understand why the court would have the power to adjudicate.
You just need to know what is included by in the term or in power to adjudicate and what's not. And it's sufficient to know what's not included to know that venue is not included and to know that you lose the argument, in my opinion.
No, because venue could be included if it's more than venue in territorial jurisdiction.
I don't understand what you mean by that. Venue could be included.
You have to, in my understanding is that the courts have to have personal jurisdiction. They have to have territorial. So in other words, court has to have personal jurisdiction. If they can't prove that they have personal jurisdiction of you, that you're not in the location where they have power over, you don't have domicile there, you don't have some connection, etc., then they don't have jurisdiction. They have to have subject matter jurisdiction. So even if they have personal jurisdiction, you live in the area and something.
So a court does need those things, right? I just don't know if they relate to the power to adjudicate the case. Like it is the case, right? Like if you lack personal jurisdiction over the case is going to be dismissed for lack of personal jurisdiction. The case will be dismissed for lack of subject matter jurisdiction. The case may be dismissed for lack of venue or improper venue. The case may be dismissed for failure to state a claim. The case could be dismissed for a ton of different reasons, right? The case could be dismissed because the judge isn't a real judge or because of presidential immunity. There could be a lot of different reasons why the case is dismissed, but not all of those reasons are jurisdiction in the sense of the power to hear a case.
And if you don't have personal jurisdiction, you wouldn't have the power to adjudicate the case.
I'm telling you, I'm agnostic about that.
Well, I just think that it's a cop-out, and I think that's...
Why does that matter? Why is that? Why is that relevant to my argument?
It's relevant because I feel it's the same with territorial jurisdiction, right? And the reason that
territorial jurisdiction is not my argument either.
The reason is, right, is because with territorial jurisdiction, you're saying in this case it equivocates to venue, which is waivable, just like personal jurisdiction.
So when I say equivocate, I don't mean is equal to. Equivocate meaning changing different meanings and using different meanings in one context versus the other. So when I said it's equivocating to use jurisdiction and in the context of power to hear a case and territorial jurisdiction, what I mean to say is in the habeas statute, it's not referring to the definition of jurisdiction that we're typically using. But I don't take territorial jurisdiction to be the same as venue. I've said that like 6 times. I'm going to say it one more time. I don't take venue to be the same as territorial jurisdiction. I think venue is coextensive, is defined in part by territorial jurisdiction, but it's a different concept than territorial jurisdiction. Territorial jurisdiction refers to literal territory in this context, whereas venue refers to where it's convenient to bring a case. So, I have the definition of venue up there. So they're different concepts. I don't take them to be the same thing.
If I understand that you don't take them to be the same thing, I've agreed with this already. I think that you could have venue and you could have anytime you lack territorial jurisdiction, you also lack venue, right? But if you lack venue, you may not lack territorial. I don't agree with that
either. I think they're totally different.
I don't think so.
So, for example, if what you mean by territorial jurisdiction is jurisdiction over cases arising in or involving persons residing within a defined territory, you could have venue and not have territorial jurisdiction in that sense, or you could have territorial jurisdiction in that sense, but not venue. But it's logically possible to have one and not the other in both cases. What you mean by territorial jurisdiction is the first definition. Okay, well, I don't know why you would disagree.
So for example, North Carolina doesn't have territorial jurisdiction over Oklahoma. We talked about this.
Sure. Yeah.
So how could it be proper venue if the venue's in North Carolina and there's a lack of territorial jurisdiction?
Yeah. So North Carolina could pass a law, and Oklahoma could pass a law. It says murders committed in Oklahoma that involve in any respect a North Carolina resident, no matter how attenuated, shall be heard. Shall be heard as a matter of venue in the state of North Carolina.
But that would give North Carolina territorial jurisdiction by definition.
No.
Yes.
No.
Yes, it would.
No, it wouldn't.
It would.
Okay.
It would either give them territorial jurisdiction by definition, or it would mean that they don't have the ability, they still don't have proper venue, even if the court said they had the Congress said they had proper venue.
In that case, the North Carolina legislature has, by definition, stated that venue is proper in North Carolina court. Notwithstanding that venue is proper in those courts, they're just unable to exercise power over the vast amount of contacts that occur in Oklahoma. And so regardless of how, venue is proper, they just, that law is of no consequence because they lack the territorial jurisdiction to exercise control over the geographic bounds of Oklahoma, even though venue is proper.
It's an absurdity. If the venue is proper, right, is the case allowed to be heard there if it lacks territorial jurisdiction?
Not necessarily.
Okay, then how can the venue be proper?
Venue can be, because venue is not coextensive with jurisdiction, and you can lack jurisdiction and lack venue and one or the other. And so you can have venue and not jurisdiction, and you can have jurisdiction and not venue. It's not incoherent.
It is incoherent. Like, 1 second.
Okay, so you're literally saying that if you lack venue, you lack jurisdiction, but that's what the courts explicitly say.
But that's not what I'm saying. That's not what I'm saying. What I'm saying is that there is a connection to the two, right? But I'm saying if you don't have territorial jurisdiction, right? What that means is you are not, you have no authority to adjudicate over the folks there, right? There are crimes, issues, property.
Wait, say it one more time. If you have no territorial jurisdiction under the first definition of territorial jurisdiction, it means that you basically don't have the sovereign power to govern what's going on in those other states. Essentially, that's how I understand it.
Right. So if you don't have then the venue could not be proper. If you don't have the power,
the venue could be proper.
Quote, venue from your definition, the proper place for a lawsuit to proceed, because the place has some connection with the events that give rise to the lawsuit.
Yeah, it is the proper place to bring.
Second, the territory such as a country or other political subdivision over which a trial court has jurisdiction. If they don't have jurisdiction, then it can't be the proper venue, even if it's declared it's the proper venue if they don't have jurisdiction.
That's what the court literally says, that's not true, that you can have the proper venue without jurisdiction. The court says that.
No, but that's because there's other types of jurisdiction. So, for example, you could have proper venue without subject matter jurisdiction. For example, why
are we delineating now? Why are we delineating? I thought we were just talking about jurisdiction.
Because all I have to do, right? But to delineate, I could say, okay, let me ask you this question: because the court says that you could have proper venue with improper jurisdiction, does that necessarily imply that you could have all types of jurisdiction?
I don't know what you mean by all types of jurisdiction.
So what you're saying is, like, for example, I could say this. I could be the court and say, hey, sometimes you could have proper venue with improper jurisdiction, right?
Proper venue with improper jurisdiction. Yeah.
Right? That's what you're saying, right?
Uh-huh.
Okay. So the proper venue might be, I live here in Pennsylvania in this court, blah, 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 right? The crime or whatever, the civil action takes place in this area where I'm at. The venue is the court that's down the road, right?
Okay.
But it's criminal court and not a civil court.
Uh-huh.
So they don't have subject matter jurisdiction.
Sure.
Okay. So in that case, it's proper venue, but improper jurisdiction.
Correct.
Okay. That doesn't necessitate that all types of jurisdiction then could occur in proper venue.
Right, but the case law that I'm relying on doesn't delineate between subject matter jurisdiction, territorial jurisdiction, or personal jurisdiction. It just says jurisdiction, and none of my argument relates to the subdivisions of it. Just jurisdiction.
If venue means the proper, the reason that territorial jurisdiction is distinct from this is because, by its definition, it is jurisdiction based on location, right? Which venue you admit has some connection to location. Your definition of venue says
not necessarily.
Okay. Okay. So this is your definition of venue. The proper or possible place for a lawsuit to proceed. So that's all about place, right? Because the place has some connection with either the events that gave rise or the plaintiff or defendant. Second, the territory, such as country or other political subdivision, which the trial has jurisdiction. Both of those have to do with place.
Yeah, generally.
Okay, so then the type of jurisdiction that has to do with place, which you're admitting is not the same as venue.
So territorial jurisdiction is a kind of, I guess it's a kind of concept of jurisdiction, but why are we delineating again? My argument does not rely on us.
It doesn't matter.
Cutting them apart.
We're delineating on this specific argument that we're talking about, that it was in this, your argument that because the courts have ruled that you could have proper venue with improper jurisdiction, right? That would imply the same with territorial jurisdiction.
No, just jurisdiction overall. Jurisdiction overall. We don't need to get to if your claim is true that territorial jurisdiction is a type of jurisdiction. My argument is I guess technically agnostic as to what type of jurisdiction could exist. What type of jurisdiction could exist with improper venue? But it's not relevant to the argument. The argument doesn't delineate between those terms. It's just talking about jurisdiction.
Proper because when you try to get out of sort of the jurisdictional claim in general, when it comes to this case, you switch back to venue. Well, you could have like the relationship with venue and territorial jurisdiction or jurisdiction in general is that you could have improper or proper venue with improper or proper jurisdiction. But I'm saying that there is my interpretation of this, which I think that you haven't successfully pushed against, is that with territorial jurisdiction, right? If you lack territorial jurisdiction, it will always be the improper venue, because it has to do with location. If you do not have the jurisdiction based
What's your citation for that?
Let me finish. If you don't have if you don't have the jurisdiction based on geographical location, then the definition of venue you provide, the proper place for a lawsuit to proceed, it cannot be proper because you don't have jurisdiction.
Under that theory, then what you're saying is if a court, why would it be the case that, if a court lacks subject matter jurisdiction, how can it be the proper court to bring it in under the venue statute, under the venue definition?
Wait, it could be with proper venue. It could be the proper.
So that same argument applies to subject matter jurisdiction, right? So if a court lacks subject matter jurisdiction, in what sense would it be the proper place to bring it under for venue?
Well, it wouldn't be proper under venue then.
Well, but you acknowledge that it's possible to lack for it to be the proper place, notwithstanding the fact that you lack subject matter jurisdiction. And so
it could be the proper district.
There's no conflict there. There's no contradiction.
It could be the proper district. How about this? You cite me the case law that you're talking about that shows that there could be proper venue with improper jurisdiction.
Proper venue with improper jurisdiction.
Correct.
Okay. Yeah. This is the Fifth Circuit opinion I keep citing. Venue is distinct from jurisdiction. Venue may be proper or improper, independent of questions of subject matter or personal jurisdiction.
Right. That's not saying what you said.
So that's one instance in which venue could be improper, and I take subject matter jurisdiction to. If you only want me to bring up the terms jurisdiction, I can do that too. Hang on.
No. But that's that's fine. But that's not saying what you said there, right? That's just saying you could have, regardless of subject matter jurisdiction, right? Venue may or may not be proper, right? No one disagrees with that.
Okay, so here we go. So this is the case, the third case I cited, which cites a case called In Re Do. It says, jurisdiction determines the instant remand issue, not venue. They're talking about the case. In fact, the venue of this action is the same location as the one plaintiff selected when he filed his lawsuit in state court, Miami-Dade County, Florida. Thus, the critical question is whether the court has jurisdiction over the action. Indeed, the cases cited by plaintiff clearly indicate the difference between an issue of jurisdiction and an issue of venue. The Doe court, in Re Do, specifically held that there is a distinction between venue and jurisdiction. Quote, venue is one thing, jurisdiction is another. They are not synonymous. Venue concerns the privilege of being held accountable to a court in a particular location. Jurisdiction is the power to act, the authority to adjudicate the subject matter.
That doesn't say that you could have proper venue and improper jurisdiction, yes, because it can't be the proper venue if they don't. It says venue concerns the privilege of being held accountable to a court in a geographic location. Right. That's what. That's how I'm using
here,
the term venue.
I'm citing the treaty from Charles Allen Wright in the definition of venue in the subnote. It says, it is possible for jurisdiction to exist, though venue in a particular district is improper. And it is possible for a suit to be brought into the appropriate venue, though it must be dismissed for lack of jurisdiction. That's Charles Allen Wright. The treaty is the law of federal courts, section 42 at 257.
I think he's using venue in the same sense that this proper, it's just the geographical location of the court, not the specific court. Right? So the venue venue could be, for example, let's say that I'm in the northern district of Texas, right? And in that northern district of Texas, there are multiple courts. There's civil courts, there's criminal court, okay?
Okay.
I think that he's saying the venue, the northern district, is the appropriate place, but you're in the inappropriate court because they lack jurisdiction.
Right. So that's an example of where venue is proper, but there's no jurisdiction. Agreed.
Right. So then
you agree that there. So you just agreed that it's possible to have proper venue and no jurisdiction.
Right. But that's exactly what I'm saying. If that's why, getting back to what I said about territorial jurisdiction, you can't have because listen, we got onto this fact because of the confusion, because I thought that when you're referencing venue there, you're not just saying the geographical location, that there are many courts there. And so you could be in that right geographical location. I thought you were saying this one specific court. That's what you meant by venue. But you don't mean that by venue.
So whether it's one or multiple different courts, I don't see how that's relevant. They're just different concepts. They're just different.
Relevant, because if it's just one court, then it's impossible to have proper venue but improper jurisdiction.
It's possible there's no venue anywhere, right? It's possible that Congress deprives all courts of proper venue.
That's true.
So venue, it's just a very different thing.
That's not what we're talking. We're talking about the opposite. If a court doesn't have jurisdiction, then it's not the appropriate court to be held, correct? Just take the simplest one that can't be waived, subject matter jurisdiction, right? Can't waive it.
Yes. So it could still be the proper place, proper venue, notwithstanding the fact that they don't have the power to adjudicate the case.
Right. So it's the location. That's the
that venue deals with location. I've been trying to say this.
Listen. This is the confusion I had. I thought that you were saying I thought that the way you were getting out of the territorial jurisdiction argument was this, because I'm making that argument, territorial jurisdiction. So let's say the Northern District of Texas, if it lacks the territorial jurisdiction, it can never be the proper venue. And you're like, no.
I don't agree with that.
What? Of course that's the case. And when you said no, it could be because,
but it's not relevant. It's not relevant to my argument.
You could say it's not relevant, but what I'm saying is when we're talking about this specific argument here, when you said no, the reason that I thought when you were like, well, you could have proper venue, but improper jurisdiction, I thought that you were then making the argument that talking about a specific court.
I thought I was very clear. Every time I'm talking about venue but no territorial jurisdiction, I'm referencing the alternative definition of territorial jurisdiction and not the place location definition of territorial jurisdiction. That's what.
Well, we can get back to that in a minute, but when
it's irrelevant. The term territorial jurisdiction does not appear isolated in my argument. The term that's in my argument is there are three kind of really important terms: habeas territorial jurisdictional rule, venue rule, and jurisdictional rule. Those are the three terms. And I don't see why we need to delineate further beyond those for purposes of my argument.
Again, when we're talking, what you're doing is now you're moving away and saying none of this matters anyways. It mattered as we got to a chain in the argumentation that was going. There, you can't argue. I don't understand how you could argue that it would be possible, especially under the first definition of the term of territorial jurisdiction, for a place to lack territorial jurisdiction but be proper venue.
If the law says, if there's a statute that says all cases must be brought in the venue of North Carolina, any case can be brought here, it's the proper venue. Okay? So imagine that. Imagine North Carolina legislature passes that, it says, okay, this court is a general court for any issue no matter what, all over the world.
Okay.
So venue is proper in North Carolina, but North Carolina does not have the territorial jurisdiction to, reach its hand over to all these other different places all over the world. You understand that?
That court does.
No, it doesn't. That North Carolina court doesn't.
Yes,
have the inherent authority to do so.
If they say, right, so it would have to be acquiesced to the other parties involved.
No, but assume it's not.
Because
right?
it would
assume
still
it's
be,
not.
but you can't declare, right? Like the same way you can't declare we have territorial jurisdiction is the same way you can't declare we have proper venue.
But but again, so I want to say that is an example in which there would be venue, but because venue is defined as a creature of statute and convenience, and the legislature in their ultimate wisdom, stupid wisdom, said we think it's always convenient to have cases arise in North Carolina, and so we're just going to say any case can be brought here. That fine, they define venue, and so they defined it in such a way that it is the proper court to bring it. It's a proper location under state law, but they don't have the territorial jurisdiction to extend into all these other matters. That is an example where territorial jurisdiction is improper, the venue is proper. That is an example of that. And, but it's also irrelevant to my argument.
That is not an example, and here's why. Because like you said, like reach over to other countries around the world. It would only be an example if it was passed by federal Congress. If federal Congress said, North Carolina, this particular venue has the ability to hear any court, then yes, it would be proper jurisdiction and proper.
You're changing the hypo.
No, so if they just say if North Carolina says we are the proper venue to hear cases from Oklahoma, they still wouldn't be the proper venue. Why? Because Oklahoma would say, no, we don't agree.
But no, who decides what's proper venue?
Congress.
The legislature of the respect. So this is another inherent difficulty here is you're mapping on the concepts of state venue and federal venue and you're using it to deploying it. There's some we can do that and we can do those analogies, but if you want to use the territorial jurisdictional arguments in the way that you're doing, you're going to run into some issues with respect to the state venue statutes. It's much easier to think of in the federal context and say, well, Congress decides which of the district courts have venue or jurisdiction, and the Congress's jurisdiction extends as far as for the federal courts extends as far as the United States as a whole. And so just keep it in the federal context, and you can very quickly see.
But the same could be said of you. The same could be said of you. For example, earlier when you said there are certain territorial jurisdiction you can't waive. For example, you made an example of we can't decide, the United States federal courts can't decide to weigh on crimes that occur in Spain unless Spain would acquiesce to it, correct?
Sorry, repeat that last part.
You made this claim that there are certain types of territorial jurisdiction that can't be waived. For example, if a crime occurs in Spain, the United States can't.
Everything is Spain. So the only way that you could have jurisdiction to hear it in some kind of territorial jurisdiction to hear it in those states, you wouldn't have territorial jurisdiction. Perhaps Spain would exercise its own jurisdiction and provide it as a matter of grace or comity to the whatever
now
court.
Venue. Now instead of territorial jurisdiction, instead of saying we have the territorial jurisdiction to hear that case, do we have the venue to hear that case?
You have the venue regardless of what Spain does.
So the United States could say it is proper venue to rule on crimes that occur from Spanish citizens in Spain. They could rule that.
Yes,
but they can't rule that. They can't rule that. They cannot.
But there would be a jurisdictional issue. The Supreme Court would probably, if Congress tried that, and someone actually tried to bring that case in the United States, the court would very quickly say venue is proper because Congress says that venue is proper. But then they would say, however, Congress cannot extend beyond the territorial jurisdiction of the United States of America, and this this case is asking the federal courts to extend beyond the territorial jurisdiction of the United States, and therefore we're dismissing for lack of jurisdiction, even though venue is proper.
I disagree. I don't think venue would be proper.
Okay,
because the very definition of venue that you've given is that it's the proper place to hear, but you just said that it wouldn't be the proper place to hear. The proper possible place for a lawsuit to proceed.
Yeah, so if what you're doing is you're trying to use the ordinary usage of those terms, then that would be just as true for subject matter jurisdiction, which you've already conceded. There is a difference in the concept in terms of the proper place to brought. It's a distinction, even though a court may lack subject matter jurisdiction, it may still be the proper place to bring the case, even though the court, in what sense would it be proper to bring it in a court where it doesn't have subject matter jurisdiction? So that ordinary usage of language argument fails because you've already granted that the subject matter jurisdiction, a subject matter jurisdiction lacking court can nonetheless be the quote proper place to bring a case. You've already granted that.
The subject matter, it could be the proper location, but not the proper court.
Okay, so then you grant that you grant therefore that venue can be proper, notwithstanding the fact that it isn't the place to bring, or that every court in that place lacks jurisdiction.
Right, because it is the appropriate place.
But notwithstanding that fact, it could be also the case that every court in that place doesn't have jurisdiction. They're different.
that if that was the case, it wouldn't be the proper venue to hear it. If none of them had jurisdiction.
Now you're just conflating jurisdiction and venue, which is my whole argument this entire time.
So wait a minute. Your argument is there's a crime that's occurred, right?
Okay.
It occurs in this particular district court. So the venues are in this particular district. So the venue's appropriate in that district. There's 6 courts there that all have different, but that's the venue.
Yeah, because let's say the state legislature, we're going back to the state's example, a state legislature has defined that venue is proper in the place where the district in which it was committed. Yep.
Okay. But no court has subject matter jurisdiction.
Yeah, that could be the case as well. Let's say, for example, the Texas state court system says the court shall no longer have jurisdiction to hear crimes. Now, the venue is proper, but they've been deprived by the legislature of jurisdiction to hear criminal cases, and so venue is proper.
So
even though jurisdiction is,
in that sense, I will concede. In that sense, you could have a proper venue, but improper jurisdiction. So no courts would ever be able to hear that.
Right, even though it's proper venue.
Okay. That would not be possible with territorial jurisdiction.
I don't know why.
Because
but again, I don't know why it's relevant to the argument.
It would not be possible because the jurisdiction is limited by location.
Okay, but again, I don't see how that's relevant to my argument,
so then
which
it
doesn't
would,
use
it could
that
never
term.
It could never be proper venue.
Suppose I concede that. Suppose I grant that. I'm not. I just want to be clear. I'm not. But even assume I did. Like, how would that change whether I'm right or wrong on my argument if I don't use that term?
Because then, if we could prove that there is a lack of territorial jurisdiction, that the only territory that you could hear these sort of habeas claims is, then that would mean that there is a lack of jurisdiction elsewhere.
No, because it's venue. So now there's an equivocation again. So when I was using the term territorial jurisdiction to see whether or not it could be, you could have territorial jurisdiction and not venue and vice versa, I was using definition 1 of territorial jurisdiction. And my contention is that in the habeas statutes, it refers to definition 2, which is geographical location. And so now there's an equivocation between which vision of territorial jurisdiction we're using for applying it to the Alien Enemies Act case.
Even if, so I guess we could, let me see if I had anything else written down. I disagree. I think that it's clear if there's a lack of territorial jurisdiction, then you don't have jurisdiction. I think when the court specifically uses the term jurisdiction, that it is fair-minded to say when there's only jurisdiction.
Wait, which of my premises do you disagree with? So now you're just summarizing your whole point?
Yes. We didn't even get, I'm agreeing with my premise that supersedes yours.
But so we're just abandoning my argument?
No, we didn't. By the way, we've been talking 3 hours and we didn't get to my premise.
I know, but that's because I think that you're cooked a little bit, and
I don't
this argument is valid and follows.
I don't think that I'm cooked. I think the best argument you have is the Kennedy concurrence and the fact that it says that it doesn't necessitate that they don't have the power. I don't think that is a positive. That is sort of negative language. I don't think that is positive, that it shows that if a court doesn't have jurisdiction, territorial jurisdiction under habeas, that means that they still have jurisdiction. I don't think it does enough to do that, particularly when the language itself says that they lack the territorial jurisdiction, that there's only one court that has the jurisdiction.
I'll open myself up to your questions because, in fairness to you, we have been doing this for 3 hours, and I've kind of been a little. Even though we're examining my argument, I'll let you lead the conversation wherever you want and ask me questions if you want, just for the next.
Well, I don't know
how much time you have. Yeah.
I don't think it'll take that long, right? Because you're going to say
cool.
It's sort of what we've been discussing, right? So I think, as I said from the get-go, even if your argument's true, so your premise was, let me pull it up just one last time. If habeas territorial jurisdiction is a venue rule, then it's not a jurisdictional rule. I don't think you've proven that.
We mean premise 2? Habeas territorial jurisdiction rule is a venue rule?
Oh, I'm sorry.
I think you granted premise 1.
We said only. We said if it's only.
Yeah,
if it's only a venue.
Yeah.
I don't think that you proved that it was premise 2 that it's only a venue rule.
Yeah, so I go to what the court said in JGG, which was that after they say for core habeas petitions, jurisdiction lies in only one district, the District of Confinement, and the detainees are confined in Texas, so venue is improper in the District of Columbia. And so that indicates to me that's strong evidence that it's a venue rule.
It doesn't say that it's only venue rule. I think particularly when it's referencing territory, and that's why when I'm talking about sort of that you could have improper venue, right? You could have improper. Let me rephrase this. When you have sort of the jurisdiction that goes to territorial jurisdiction, all cases of territorial jurisdiction, or even, I don't even have to win all, but many cases of lack of territorial jurisdiction will also, in addition, be lack of venue. Would you agree with that?
Wait, sorry.
So
all
let's take out the word all.
Venue?
Let's take all.
Oh,
like
sorry.
many, sorry. My computer keeps glitching on here. Many instances of lack of territorial jurisdiction would also be lack of venue.
I don't know what that means.
So, for example, could
I see them as different things. I would say no.
Could a court simultaneously have improper territorial jurisdiction and improper venue?
Yes.
And so saying,
if by territorial jurisdiction you mean the first definition, yes.
Regardless, right? And so by saying that it doesn't have jurisdiction and it then saying so it doesn't have venue, that does not necessitate that it also doesn't have territorial jurisdiction.
I think they're independent of each other. I don't know if that answers your question.
Okay, if they're independent,
one or the other, not the. Yeah.
Then it answers my question that no, it doesn't.
Okay.
So when you're like the core confusion, I think, of what's going on with your syllogism is that you had to add the word only, right? And so we got to adding the word only.
That's what I meant the whole time. But yes, I did add it for clarity. Yeah.
I'm not saying that, right?
Yeah.
But what I'm saying is, so when we look at premise 1, right? Okay, we could move on to premise 2, but only has to apply in premise 2 as well, right?
Correct.
Right, and I don't think you've met that burden.
Okay.
How do you feel you've met that burden? If you acknowledge that there's no real connection to territorial jurisdiction and venue, how do you feel you've met the burden? When they mention venue, that isn't dispositive that they're saying, and there's not also territorial jurisdiction issues.
Yes, because I think that when they use the term territorial jurisdiction in Kennedy's concurrence, they're referencing geographic location. Kennedy's concurrence literally says the territorial jurisdictional rule is a venue rule. That's what his concurrence literally says. I think that's strong evidence. And then he doesn't say territorial jurisdictional rule is a venue rule and a jurisdictional rule. He simply says it is a venue rule. And then he goes on to say it doesn't refer to the power to adjudicate the case. And then I think the strongest piece of evidence is the most recent Supreme Court decision that after they're talking about jurisdiction line in only one district, they say so venue is improper, and that to me is strong evidence that it's a venue argument, just like Kennedy suggested. And so, and then additionally, there's the provision of the treatise by Charles Allen Wright, who again is a leading treatise writer on federal practice. It says the most important difference between venue and jurisdiction is that a party may consent to be sued in a district that otherwise would be an improper venue, and it waives its objection to venue if it fails to assert it promptly. This is in striking contrast to subject matter jurisdiction, which cannot be conferred by the parties. And so, at least by the leading treatise writer, he seems to suggest that waivability is a big indication that of the difference between venue and jurisdiction. I'm not saying that, again, I'm agnostic as to personal jurisdiction, which can also be waived, but I think all of that is a strong indication that P2 is correct, that the territorial jurisdiction rule under habeas is a venue rule.
But the writ that you just read, I think, again, it makes the point that I'm trying to make, that they're specific about that it doesn't lead to subject matter jurisdiction, which was your argument from the get-go, right? This entire exchange started with me saying Boseberg didn't have jurisdiction. You're like, he did have subject matter jurisdiction. I'm not arguing that he didn't have subject matter jurisdiction. And I think that that's same thing. And I think that evidence to suggest my side is correct is when you look at the Kennedy concurrence, when he specifically says that there's not jurisdiction, he doesn't say there's not jurisdiction. He says these rules are not jurisdictional in the sense of limitation on subject matter jurisdiction. So he doesn't say these aren't jurisdictional. He's saying, no. What I'm talking specifically about subject matter jurisdiction. It seems
but
like
if you grant it's a venue rule, then if you grant it's a venue rule, then it's not a jurisdictional rule if it's only a venue rule. I think, and I think you granted that. And I think,
but you haven't proved that it's only a venue rule.
Well, I think I have, and I'll leave that to the discretion, I guess, of the audience, since we've been going at it for a little bit. But there's, and I don't know if you have anything more to say on it, but if you don't, I would like to raise. This is all done in good faith.
Can I?
Good. Yeah.
Can I?
Sure.
Two arguments I had was premise 1, jurisdiction is the court's power to decide a case or issue a decree. Premise 2 is Supreme Court ruled that Boseberg did not have the power to decide this case or issue a decree.
I think that's false.
I think that's true. I think that if he had the power, they would have allowed it.
I take power to be what the court says is the power to adjudicate a case, which it distinguishes from venue, and so it grounds out to the same thing. But I would probably agree with premise 1, and disagree with premise 2.
Well, I take power to mean the ability to act.
Okay, I think that's a proprietary definition in this specific context. I don't think that's.
I mean, I would love. I
think
don't have
yeah.
I don't have Black's Law in front of me or anything. I don't know if I could get it, but I would love to see
I'll
how
send
they
you the
define
PDF at some point.
Well, how
Yeah.
do they define power? Can you just let's see? Maybe I do have it.
Okay, I'll look for it. Hang on.
It would be interesting to see. I think that would at least be.
Give me a sec. No one man should have all that power. Again, I don't think it's strictly speaking relevant, but we can definitely do it in good faith. Do you still do like when you're doing the ABCs, LMNOP, and like do the ABCs in your head?
I don't. The reason is because I have a kid, and so I've stopped myself from doing it because he was doing it. So I had to because
teach you to
you
memorize
realize, yeah, when you do it like that, it's like, oh, he thinks elemento is a letter. Like, so I specifically now for the past couple of years, it's LMNO because of that.
LMNOP. All right, let's see. Power. It's a lot of words here, right? So I'm almost there. And I can't just control F because it'll just give me all the... Okay, here we go. Power. The ability to act or not act. A person's capacity for acting in such a manner as to control someone else's responses. 2, dominance, control, or influence over another. Control over one's subordinates. 3, the legal right... Or, hang on, I'll just copy paste this so you can see it. Hang on.
Where are you going to put it? On your X thread?
Yeah, I'll tweet at you.
Okay.
I'm living in the 21st century, doing something weird. Hang on. Wait, it's not letting me. 1 sec. Scream from the haters, got a nice ring to it. I guess every superhero got a theme music. Okay, I'm just going to DM it to you on Discord. For whatever reason, it's not letting me post it.
Great.
This is going to be great content. Here we go. So it's power, the ability, and maybe you can bring it up. I don't know if you're able to do that.
This power, the ability to act or not act, a person's capacity for acting in such a manner to control someone else's response. I don't know that really applies here. Would you say that's fair?
Yeah, I think power in that context of jurisdiction is like a specific thing that I'm referencing.
Number 2, dominance, control, or influence over another, control over one's subordinates. Number 3, the legal right or authorization to act or not act. A person or organization's ability to alter by an act of will the rights, duties, liabilities, or legal relations either of that person or another. Power is the capacity to change a legal relationship. In this terminology, the offeree has, before the contract is made, a power to create a contract. I would say that third definition is probably what's most likely, right? Referencing the legal right.
I think it's kind of specific to the context of jurisdiction, and the power in that context means what the courts tell us it means. That's how I ground it out.
No, I think that it's specific.
Are in the category of power, like, and some are not.
Which definition do you want to go with? 1 and 3? 2 does dominance, control.
I don't go by those definitions. I think that power should be in the context of jurisdictional power should be defined by what the courts say is the power.
Right, but the courts aren't specifically saying. The courts are saying that these courts do not.
The courts say things that are venue don't get to the power. That's what they say. And so you can have a definition.
The courts specifically say that they don't have the ability to act. Only one court has the ability to act.
Again, there's an equivocation. The courts are using power to mean a specific subset of things that get to the court's inherent, to a given court's inherent authority. But there are some things that are included and some things that are excluded. It's not speaking and using that common definition that you're implying there. It's getting to a more specific, more granular, and informed by case law set of instances. That's what I mean.
Think that we should prefer definitions that come from the same source. If we accept Black's Law definition for the definition of jurisdiction, and it includes the word power, wouldn't you think it's reasonable to interpret that what they mean by power is what they also define in that same book as power?
I don't know why that's relevant to our argument.
Because then if we could say that the definition of jurisdiction that we're accepting is Black's law, and so if we say the power to issue a decree or adjudicate,
My
and they
argument is not
define
about
power-
which words we should, what definitions we should use. My definition, that's not what the debate is about, which definitions we should use.
Well, of course, if we're determining whether or not what the word jurisdiction means, you don't think that that's crucial to sort of this debate, whether or not the Supreme Court said they have jurisdiction or not?
No, I take that to be like an argument about language philosophy, not about what whether the jurisdictional, sorry, the venue holding has anything to do with jurisdiction. I take them to be two separate things. One is a question about what is preferable in terms of language.
I completely disagree. I think that the definition, in order to determine whether or not the Supreme Court said that Boseberg didn't have jurisdiction, we would need to understand what jurisdiction means. We have to have an agreement on what that means, or we have to have.
I'm telling you what's basic, what's grounding out my semantics. That's semantic, right? So I'm telling you where I'm getting the semantics from. And we can have a separate conversation about whether or not we should prefer the semantics I'm using, and we can get into that. But I'm telling you what the semantics mean. And
how about this?
Yeah.
Given the definition that we've read from Black's law, if this is all you had in front of you, would you agree with me, given this definition and the definition you've given as jurisdiction, that yes, given as what they define as power, that it was that the Supreme Court ruled that Boseberg didn't have jurisdiction?
I don't know, and I don't know why answering that question is relevant.
Because
if all I had, you're saying like if I didn't have this case law, would I be able to make the case? I think that my argument depends on the case law. So I think absent the case law, I don't think my argument goes through.
Okay, so then my argument would supersede if you didn't have what you're interpreting as the case law.
Yeah. So I think that my argument really relies on the case law, because that's where we get the habeas. That's where we know what is meant by the habeas statute. And so without that case law, we're unable to make my argument go through. I agree.
Okay, so I think that I disagree on your interpretation of the case law, as we've spent hours talking about, right? But I think that it is fair for me to say, given you have no reason to accept that this is a bad definition of the word jurisdiction or power, correct?
I don't know what you mean by bad definition.
Like, it's not a definition that's in bad faith or a definition that's so out of bounds that it's absurd.
When you say bad faith, is
it a definition that a reasonable person could say yes? I mean, it's coming from a legal dictionary.
Sorry, so could a reasonable person come to the conclusion that that's and if by good definition you mean that we ought to use that definition?
Sure.
If what you mean by ought is it's a preferential to use it, I think that it's very possible that a reasonable person could prefer to use definitions in Black's Law Dictionary. But I take this to be kind of like an area where it's like kind of a term of art, and where there's specific technical stuff that matters. So regardless of what a reasonable person would come to a conclusion, I don't know that's relevant to the argument.
But I'm glad for that concession, that a reasonable person could look at that and say, yes, Rob is correct if we're using the Black's Law Dictionary that they ruled he didn't have jurisdiction. Now, just two more quick things.
But that's a little tricky, Dickie, because at the very least, if you're going to say that, then you should be better faith with me that when I was bringing that up, I'm not trying to fuck with you. I'm not trying to use legalese to occult something. I'm trying to actually be good faith, and I see something where there's potential confusion, and I'm bringing it up for a purpose of being good faith and saying, well, no, I don't think this is right. And in fact, I think it is not just semantic, because it gets to the overall heart of the argument, which is Boseberg acting in bad faith? Is he a political actor? And I think your priors about whether or not the ruling speaks to his specific jurisdiction, or whether it's a more in the weeds discussion about the habeas venue stuff, that changes your prior on whether or not you think Boseberg is a good actor, or is lying, or is politically motivated. And so I don't think that it's bad faith for me to bring up that distinction, or it's just me quibbling. And that's kind of what you implied. So
I promise I'll get there. I just want to talk 30 seconds here. So my premise that jurisdiction is the court's power to decide a case or issue a decree. Supreme Court ruled that Boseberg didn't have the power to decide this case or issue a decree. Therefore, Supreme Court ruled Boseberg did not have jurisdiction. I think that that's still the premise I'm going with, and that the concession I got just there shows that that's reasonable. Now, to get to, I understand you disagree. Based on
a reasonable person is a lay person. All right, a reasonable person is a lay person. And a
Fine,
layperson,
fine.
you know, okay.
Nonetheless, and I still disagree with your interpretation for reasons said, but we can't sit here all night.
Okay.
Well, maybe we can.
Yeah.
Now let's talk about
No, please end me.
now let's talk about sort of like the good faith nature of it. This is what agitates me, right? Because if you're willing to admit that, how did we get in this conversation to begin with? When I'm making this argument where I'm like, look, Boseberg didn't have jurisdiction, right?
You said he blatantly didn't have jurisdiction, and the argument you're making is that he's a hack.
Correct. That's what I'm saying, right? Now, so when I say, you could have said, I don't think he's a hack, right? And my understanding of jurisdiction is different than yours, but what do you mean specifically? Right. And I would have told you what I meant specifically was, because what I was reading, regardless of what you want to mind read to me, I was not saying subject matter jurisdiction. Now, this should be evident to you because I talked to you previously about problems I had with Trump's invocation of the Alien Enemy Act. And one of the things I said was, I think that it's likely that the Supreme Court is probably going to say the following. Look, this guy and his sort of turn the planes around nonsense, forget about that. He didn't have the authority to do that. It was improper form, location, etc. However, these people are entitled to some sort of due process. Now, that due process may not be what me and you would be entitled to as citizens. And I think that not only was that legally what was likely to happen, which I think is basically what happened. I think I was right about that case, but I think morally is what should happen. Because
hang on a second, dude. I mean, you're saying what you meant by he didn't have the jurisdiction there isn't this kind of in the weeds habeas, jurisdiction, territory. What you meant is like the court doesn't have the power to turn planes around outside the United States.
That's not all I meant. I also meant that this guy specifically had no business ruling on it. He had nothing to do with it. He was in a district that had nothing to do with
this. This in the weeds stuff about the habeas jurisdiction stuff and Padilla. The in the weeds stuff about Padilla and the specific like if this had if it were a Democrat appointed judge in Texas who said the same thing, you would still say your argument that he didn't have the jurisdiction.
No.
Just be honest.
The argument about turning the planes around is different than not jurisdiction.
Yeah, hang on a second. If this was like a Democrat appointed judge in Texas who issued the same exact order, be honest. Would you say, oh yeah, no, he definitely had the jurisdiction? You wouldn't say that.
This is what I would say. This is honestly what I've said, and I could give good evidence of success. I'm telling the truth. I would have said, look, it's absurd that he would say to turn these planes around, etc. But I think that he has a point that we need to have assured that there was some level of due process, because what we can't have, I have no problem. And we're going to disagree on sort of the due process afforded to illegals in general. That's different, though, than sending someone back that's here illegally to their country of origin is different than sending someone to a country they've never been to go to prison. That's fucking different. And so there has to be some higher level of due process than just we're sending you back to your country.
No, but you kind of dodged. I asked if the Texas court, if the order had issued, the TRO should turn the, strictly speaking, the order wasn't turn the planes around, but assume that it was. And that's what people understood it to be. Mm-hmm. If a Texas court had said, turn the planes around, you would have said, they don't have the jurisdiction to tell the president to do that.
No, I wouldn't have said that. I would have said, I don't think I would have used the term jurisdiction. I would have said they don't have the authority to tell them to turn the planes around. But
that's what we mean by jurisdiction. That's the authority.
What I meant by jurisdiction, for me, what it always meant to me was like not just the power to adjudicate, but being in the right area, right? The problem I had with Boseberg from the get-go was the idea of forum shopping, where what happened was they went to an area that had no connections in DC. And you know that I hate the DC courts. Like I've talked about this with January 6th. I think that they're a joke. I think that they're overwhelmingly Democrat and left wing. And it seems that all of these appeals are coming out, not just at the DC court, but particularly Boseberg keeps getting these cases. And so the problem seems to be Boseberg keeps, litigants are forum shopping, going to Boseberg because they know his proclivities. He keeps getting these cases and he keeps making these rules, and he has nothing to do with it. He's not in the right jurisdiction. The correct jurisdiction would be where, like, I will be honest with you, I wouldn't have been fucking knowledgeable enough to know, is it where these people were captured from? Or is it where they're confined?
That's what I mean. So when you said it in our debate, you weren't talking about what we're talking about now. So you didn't mean that. And so it's post hoc what we're doing here.
That's not true. What I meant was they didn't have jurisdiction basically because of the territory, which is exactly what I'm talking about in this debate. that I would have been, I'm telling
territory. No, hang on. Territory as relates USA and USA airspace, not territory Texas versus DC.
No, that's not true. I'm telling you.
You think what you meant was okay.
What I think that the proper place to hear these claims would have been where they were picked up from or where they're being held. Not some liberal judge in one of the most liberal circuits that's like, yeah, I'm going to weigh in this and immediately say, turn the planes around.
Wait, so you think that your territorial argument related to Texas versus DC as opposed to United States versus not United States? You really want us to believe that?
No, I'm saying there's a separate argument that I don't think I would have said was jurisdictional, which was the idea once these people were there or once the planes were in the air. That's a separate argument altogether from the jurisdiction argument I'm saying. Now, it could be jurisdictional as well in that, and I think even Boseberg admits this in his TRO, right? If he had not issued that TRO until they were already on the ground in El Salvador, it would have been outside of its jurisdiction.
I just want to clarify for the audience, the way Boseberg is, and this is one of the issues that is going to be on appeal. I think if the TRO, the contempt is overturned or something, it'll be on this. Boseberg says that his order clearly meant don't hand it over to El Salvadoran officials. That's what he took the TRO to mean, and the kind of turn the planes around was an indication that he was referring to legal handover as opposed to, or he's basically, if you read the contempt order, he's not saying that the TRO related solely to turning the planes around, but to preventing them from handing over the people to El Salvadorian custody. So I just want to make that clear for the audience. But,
and even if you read the TRO, it's only 3 pages, right? He even makes claims that further buttress the arguments that I'm making surrounding territorial jurisdiction previously in the discussion of your premise.
Once they're in.
This is what he says, right? He says plaintiffs will suffer irreparable injury and balance the hardships. God damn, this is small font. Old man stuff.
You know,
and the public interest, real quick, and the public interest in favor relief. Critically, moreover, if the plaintiff's removed to the custody of another country, quote, this court will lose jurisdiction.
Yeah, so he was wrong, but he was wrong about that. And the Supreme Court held as much in the Abrego Garcia case. And so, yeah, I understand. Boseberg made that jurisdictional argument with respect to the El Salvadorian custody situation, and he was overturned by the Supreme Court in the Abrego Garcia case.
But wait a minute.
But that's not what happened there.
So the Supreme Court said that, no, he wouldn't lose custody if they were... That's what you're arguing?
No, the federal courts do have jurisdiction to issue orders as pertains people in El Salvadorian custody, and that is evidenced by the fact that they did give an order with respect to Abrego Garcia, and so Boseberg is obviously wrong about that.
Well, it's clear that Boseberg believes in the idea of sort of jurisdiction when it comes to territory, right? Like, so he's certainly so it further punches. But again, the point that I was making when I brought this up to you, and I was saying that he didn't have jurisdiction, I'm saying he wasn't the guy that was able to issue this. They forum shopped, and you've conceded that this was forum shopping.
So you meant, yeah, it was yeah, they're going to DC, but it doesn't mean it's improper. The conservatives forum shop as well. That's just the
certainly
rules.
Improper. I mean, do you agree with the justices that said that this would be a problem when it came to habeas petitions? That you'd have people with this long arm doctrine that would always be going to places where they thought that there would be judges.
That's probably one of the reasons why it's important to have venue accommodations.
And
but
so
again,
I don't
know why is that relevant, Rob?
The reason it's relevant because we're speaking to what I meant when I was talking about this guy not having jurisdiction. If you follow any right-wing people or people that are critical of this sort of stuff, you'll see that constantly the argument is that what happens is it goes to these left-wing areas that basically don't want to deport anyone. They want to keep everyone.
So if a Texas judge issued the same order, you would have been fine with it.
Except for the turn the planes around portion, yes.
Okay, I don't think that's right. And I think that's evidenced by the fact that there's a bunch of Texas courts right now. So just today, a Texas court said that the invocation of the Alien Enemies Act was outside of the president's authority. A Texas court just said that, and he's a Trump-appointed judge, and everyone is losing their fucking minds.
Well, maybe, but that's not necessarily a jurisdictional issue. I might disagree with the merits. Well, but let me be clear.
I think that it's preposterous to think that you were thinking about this specific issue when you said that in our conversation.
Again, why would that be the case when if we take the legality out of it, what's my moral position?
I don't know, and I don't know why it's relevant, but you can tell me.
It's relevant because the conversation
that I had, but I don't know.
The conversation that I had with you prior to the conversation that started all this, I said, I think that there's a problem with this. I think that the idea
Okay.
that you could just load people up, and I even made the argument, I was like, listen, this is the one area where maybe they could do this to a US citizen actually makes sense, right? Because my understanding is if we could just load people up and say you're a member of MS-13, I don't know, maybe I'm wrong about this. Couldn't you do that? Could you invoke Alien Enemy Act against a US citizen if you also said that they were working in tandem with this terrorist gang organization that was sent by Venezuela? Arguably, right?
That's what Trump is saying he wants to do.
Yeah, that's fucking crazy. I disagree with that totally. Now, the question of what sort of due process should be offered, those are things we're going to disagree with. But the point is, that was my position. I actually,
but that doesn't have to do with that's not relevant to the argument. No, I appreciate you for saying that, and I was wrong when I said that you didn't criticize it substantively, and I acknowledge that in our conversation that I was wrong when I said that you didn't acknowledge that when you did. But
it's you claiming that you're reading my mind, that I know what Rob was talking about was subject matter jurisdiction, and
I think it's preposterous that you were thinking about this specific habeas jurisdictional argument.
I wasn't thinking about this specific. No, don't misunderstand me. I wasn't thinking. I was thinking this fucking judge doesn't have the authority to rule. He wasn't in the proper location because he wasn't. These people had no connection to him. They weren't in his district when they were picked up. They weren't in his district when they were jailed. That's my argument.
Okay. Now, I'll take you on good faith that that's what you meant.
The problem I have with you is, right, the idea that you bring this up on subject, the general thesis of, this dude didn't have the authority to make that TRO is true. And so the semantic argument of, well, was it just because of venue or because of jurisdiction is sort of nonsensical.
No, it's directly relevant, Rob, because if you're going to argue that it was blatantly obvious that he couldn't do this, then it matters. Well, how obvious is this error, right? You'd agree that's absolutely relevant. So whether or not
was it blatantly obvious that he was in proper venue?
No, it wasn't blatantly obvious that it was in proper venue because so first of all, there were no habeas claims. And so Boseberg acknowledged that if there were habeas claims, he wouldn't be the proper venue. That's why he suggested to the plaintiffs to get rid of their habeas claims because he would have to dismiss them for lack of venue. And so they amended the complaint. And so what they were bringing were APA claims related to the Alien Enemies Act case. And it was not obvious that you couldn't bring Alien Enemies Act claims related to the APA. That was not obvious. And the evidence for that is it split the DC Circuit 2-1 in favor of what Boseberg's opinion was. And the Supreme Court split 5-4 in favor of what Trump's position was. So this was not obvious.
I disagree. I think it was obvious. I think it was obvious that this guy with no connection. Okay. Now, I think it was. Now, the APA, by the way.
What's the argument there? That it was obvious that the APA couldn't apply in cases of the Alien Enemies Act? What's the argument that it was so obvious? It was blatant.
That this specific judge invoking the APA didn't have the jurisdiction, the location to.
No, but for APA claims, sometimes there's the exclusive place to bring them is in the District of Columbia.
When? Where's the evidence of that?
I don't have the specific statute, but just assume that that's the case. Then you don't have the relevant background to say whether or not APA claims should be brought one place versus another place. And so I don't know. Like it just seems that you're making assumptions.
I think that when I'm watching people like Shipwreck Demon that from the get-go are like, what's this judge doing? Like he isn't the judge for this. They're clearly judge shopping.
It's not steeped in a knowledge of the Administrative Procedures Act and its interaction with the Alien Enemies Act and how obvious it is. And I should isn't the fact that there was the DC Circuit Court of Appeals, where there was 2 conservatives and 1 liberal judge, split 2-1 in favor of Boseberg, and then it was 5-4. On this Alien Enemies Act claim. It was a very split Supreme Court on this very issue. In what sense was it "quote unquote" obvious? That just doesn't seem right to me. And it
to me, I think that it was obvious that he wasn't the judge to do it. By the way, real quick, the APA, right? The fact that he was overruled that he couldn't use the APA. Does that mean that he lacks subject matter jurisdiction on matters of the APA?
No, and that's why this is the last. So this is the funny part is, Rob, and I'm about to answer that question. I just want to assure you. Funny thing is the Supreme Court's case isn't even about jurisdiction or venue, right? They talk about that.
I disagree. I could argue this because
in reality, it's a case about whether or not you can state a claim under the Administrative Procedures Act with respect to the Alien Enemies Act case. So it's not a jurisdictional or venue claim at all. It's a ruling on the merits that. For failure to state a claim, you can't bring this under the APA, and so that's why Boseberg says in his contempt opinion at worst, right? Because really, there were no habeas claims at all to press because they were all amended out of the complaint. The only thing left were APA claims, and the APA claims had proper venue, proper jurisdiction, and the only problem is, well, can you bring habeas under the APA? Answer being no, and so the case is going to be dismissed for failure to state a claim or cause of action. And that's why before he talks about venue, he talks about APA and the alternative venue, whatever the Kavanaugh concurrence says, is because that's the principal holding, is that you can't bring habeas or Alien Enemies Act cases under APA.
So it's not a jurisdictional claim; it's just he incorrectly applied a law.
Right. So it would be like him saying, you're allowed to. So this is the place you're bringing this case on the Alien Enemies Act under the, under the some kind of transportation statute, which just obviously doesn't apply. What they would say is, okay, jurisdiction proper, venue proper, but you can't bring this Alien Enemies Act case under this unrelated transportation statute, and so the TRO is unlikely to succeed on the merits because it doesn't apply, and therefore it must be dismissed for failure to state a cause of action. So even though you have jurisdiction and you have venue, you just dismiss because you lose.
Fair enough. But the reason that jurisdiction still applies is because I think what the court's doing is saying, because you can't rule this way under the APA, are there times when this judge would have jurisdiction? Or let me backtrack a little. Are there remedies?
I think they're trying to clarify.
Are there remedies? So they say, right, that's when they're talking about subject matter jurisdiction. They're like,
it's kind of dicta, though. It is kind of dicta. So what they're doing is they're assuaging the fear of the American people that there is some process, but it has to be under habeas petition. That's what they're saying, but it's kind of not related to what is before them, and it's a little bit dicta. Not to say that I don't appreciate it from the Supreme Court saying that.
So it still gets to the matter of jurisdiction, and I know you disagree. I think they're saying he didn't have jurisdiction to rule on habeas claims. Right, he doesn't, because only one court has jurisdiction, and that is the jurisdiction of confinement. I understand you disagree, but that's what I'm saying. The idea that, well, the irony is this case didn't discuss things like jurisdiction. Well, it de facto does when it takes it to the step further.
Okay, we're at 4 hours.
Yeah, that's fine. I'm willing to go. I'm willing to take the concession that a reasonable person of layman would agree with the using Black Law's dictionary. I still think that even a person who is more specific should agree that if you're going to use a definition from a legal dictionary for what jurisdiction
but Rob, you didn't use Black's Law Dictionary when you were talking to me. You understand that, right?
Yes. But listen,
so why are you incorporating it?
But the reason we're talking I think the argument was semantical and nonsensical from when you had this big, but it's not subject matter jurisdiction, whatever. That's one issue. The second issue is then you invoke your status as like, well, I'm a lawyer and I have this more specific rationale. No. Listen to me. Listen, right? And so you invoke this. And so it's like, well, are you technically right? And so that's where I go further from there. I'm like, I don't think you're technically right. I think even in a technical look,
but whether you're technically right doesn't depend on what a layman would think about legal concepts. Okay, well, so it's not a concession at all. Whether or not, so if your argument is just about who's technically right, that's what I took the argument to be. It doesn't depend on what a layman would think of these terms and whether a layman would say that it's appropriate to kind of cut and paste the different definitions from Black Law Dictionary. That's not a concession at all worth your salt. I mean, it is
a concession worth my salt because it proves that yes, when I initially made the claim, that a person could have said that it is still technically correct, that a reasonable person could believe that. So that meant that reasonably, when I made the claim, he didn't have jurisdiction in the first place for you
based
to go
on
off
Black's Law Dictionary that you didn't read at the time, and you didn't even think it was a Black's Law Dictionary.
Let me finish.
That's crazy.
So then it would have been reasonable that when you went off on your tirade, oh, it's not subject matter jurisdiction, that was totally irrelevant, that it's just sort of quabbling and being weaselly over nothing. That's what it was.
Wait, no, sorry. So now I'm going to put on big events. You agree that it's relevant to bring this out because it gets to the heart of whether or not it's how blatant it is that the mistake is, obvious to get to political bias of Boseberg, right? It matters what jurisdiction you're talking about because it changes your intuition about how blatantly wrong he is for purposes of establishing political bias. Yes or no, is it relevant for that?
No.
Okay, so how obvious a principle is, it has no bearing, has no probative worth on whether or not someone is politically biased. You know, how right he is, how wrong he is. So everyone can see, Rob, that You can't
That's not
give ground
true.
on anything, even the
You
bare
ask a
minimum of
yes/no
relevance.
You ask a yes/no question, and then you pontificate afterwards instead of allowing me to
Okay,
explain
yeah,
my
sure.
answer. Right?
Finish. I'll give you your word. This conversation. I mean, I just want to say, very disappointed. I think that you should give more ground than you have. I think that it's obvious that you're uncomfortable with the conversation because you know the argument plays out. I've been in super good faith this entire time, just like I was in super good faith in that initial conversation where I was just trying to bring clarity, provide definitions, and instruct your audience and my audience who wouldn't have been apprised of this difference. And if I hadn't spoken up, reasonable people, I think you would agree, might interpret when you said jurisdiction to mean something else. And so in what sense was it bad faith for me to apply, a technical expertise or knowledge that I have and just bring it to bear and raise it? But you take that as something super negative. I think it's very unfair. I think you're characterizing me as a bad faith person. I'll give you the final word because it's just sickening, honestly.
I mean, again, so like you asked this yes/no. This is something that you like to do a lot. Yes/no question, then spurg out. Okay, great. Let me explain why I gave the answer no. No, I don't think the way in which you approached it, where you went off on this tirade, right, about, well, no, they had jurisdiction, they had subject matter jurisdiction. I think the way you could have handled it is like, yeah, okay, I see what you're saying. You don't think this guy was the right guy, but I don't think it was as blatant as you said. Now, the reason is he was looking at the APA. See how that's much more thorough and much less just being slippery and trying to like slide out of the conversation, right? The point is, yes, because you started immediately to conflate the term subject matter jurisdiction with jurisdiction. And what it was a block of sort of like verbal text that you were making where it's just like, well, subject matter jurisdiction is not the same as that, and diversity jurisdiction, blah, blah, blah. And you're like, when you talk about being good faith, it's like you constantly like, it's not that you're like, I'm giving concessions and stuff. No, every conversation with you is like pulling teeth. Like, for example, when we had the term, like, you're like, well, well, technically, hat could mean shoe if no words mean, like, that sort of stuff's nonsensical. Everyone knows that that's outside the realm of like.
So you were contesting premise one. If you had the courage of your conviction, just like I did, the minute you gave your conviction, I said, okay, I agree on premise one. Premise two is where I'm going to fight. You couldn't give ground, and you were arguing for at least 45 minutes that it's logically impossible for a term that includes another term to be to not be a subset of that initial term. And so that to me is bad faith, where you're very scared about where it's going to go. I mean that to me,
you do this stuff all the time. It's like, well, could we kick a person out for liking orange juice? Like, you take it to an ad absurdum direction. Like, I could, if I did the same, think of how insane it would be. Like, I could be like, well, couldn't it be possible? Isn't it theoretically possible that all the case law you're reading has all been fabricated, and that there was a big change right around the time that you entered
would say
law
yes.
school?
No, I would say yes.
Okay,
Yes, it's possible.
You wouldn't. You would be like, that's fucking
yes, I would say
stupid.
yes. It is possible. If what you mean by possible is logically possible.
I guarantee
I've said that before.
This is what you would do. This is what you do. You'd be like, well, this is such an absurd blah 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 blah. Yeah, I guess maybe blah 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 blah.
I don't care about the meta anymore. Yes, let's just close it out. I don't care about the meta anymore. Do you have any final words?
No, despite the fact that I think that it's sort of slippery when you do this sort of stuff. These are conversations I like.
Yeah, me too.
I don't.
If not, I wouldn't be here for 4 hours. But yeah, I'll give you the last word, and I have to go.
3.5. No, that's it. I don't need a last word. I think that we both made our case. I think that I'm correct on the issues. You think that you're correct. That's fun.
Yeah.
Right.
Hey.
Can I tell you something?
So
you want to hear a secret?
What's the secret?
Shit. I don't even know if I should say this. I think that one of the people that I like that's a lawyer agrees with you.
Yeah, because he literally says
who? Not Mr. Ubercross. Mr. Ubercross doesn't agree with you.
Who?
It's not him. It's potentially criminal.
Oh, hell yeah. I mean,
you should ask him. I think he agrees with you.
Shouldn't that be some indication? If even the conservative lawyers, the one that you respect, potentially criminally, Sean, and Mr. Ubercross are saying, I'm right, why aren't
Mr. Ubercross isn't saying you're right.
Well, at least on the notion that jurisdiction never means venue, as we said. Jurisdiction never means venue.
Right. So when he's saying that there's a lack, he's saying that in reference to me saying there's a lack of territorial jurisdiction. He's saying that doesn't mean venue. That means specifically lack of jurisdiction. That's when he was saying that.
Okay.
That's his.
All right.
But potentially criminal. Like, look, I think that there are lawyers that have focused on this more. The reason I got this whole argumentation even before I talked to you was Shipwreck Demon, who I think's been great on these cases, who's like a practicing attorney of 30 years, who specifically said, look, it was clear that Boseberg didn't have jurisdiction. I was reading that shit for months, right? That's where I got the argument. Well, I disagree.
We'll see him and well, he won't be there, but Will Chamberlain will be there on Saturday. But hey, I appreciate. I have to bounce because I'm losing my marbles.
Okay,
but
fair.
I appreciate your audience. Appreciate the conversation, and yeah, we'll talk soon.
All right, see you.